What's it for listing of a review petition on 28th, my lordship, passing order 1/6/2026, my lord, directing the board of Assam State Housing Board to consider it a ROP. But in fact, later on, we discovered that particular order was cancelled. That particular minute was suppressed, my lord. In fact, in 2019, that has been adopted, and the government has issued sanction money, and they have received it. My lord. That's why on 9/29 they are calling for a meeting. So on 28, let it be there, madam. I filed on 20, it has already been numbered.
Right. May I please, your lordship? My lordship was pleased to allow listing of 2 items today, my lord, but it has not come up, my lord. My lord, kindly eviction matters. Oblige me.
May I have lordship? I'm saying for listing the 3 repetition lordship. So if possible, lordship, they can have on 30 lordship, already fixed matter lordship, yet, but it hasn't been mass about lordship.
Meet please. Lordship, back to item number 7 to 10, Lord. In this case, we have filed additional affidavit, Lord, that is not come on record, Lordship.
7 to 10.
Lordship. So my learned friend also received, my learned friend, Lord, for a respondent has received it on 21. So they also said they will need time, Lord. So can it be on 10th of February along with the additional affidavit, Lord?
7 to 10 on the request made by Mr.
Kela, Lord.
A. Lal, counsel for the petitioner, matter stands referred. It is submitted that additional affidavit has been filed. Of registry to trace out the said affidavit and connect it to the case record.
On 10th of February, Lord. 10th of February.
Thank you, Lordship. Lordship, I pray for listing of 3 tax matters next week, Lordship.
Did it? 28th.
Wait, please, Your Lordship. Lordship, I beg to mention item number 13 and 14. These are connected matters. Lordship, the standing counsel, Mr. S. Chetia, is having some personal difficulty. Lordship, may kindly take up this matter after 2 weeks.
13 and 14.
13 and 14. And for the
Matter
respondent.
to be called up.
I am for the petitioners.
You wait.
May I please, Your Lordship? With the concern of the other side, I beg to mention item number 5, Your Lordship. Can this matter be taken up after 3 weeks?
No, wait. Why? What is this? Every matter that is listed, you want time on some other date.
Lordship, we need to file reply, Lordship.
No, what? I don't know. You wait. Every matter that comes up on every day, you want a time.
Lordship.
Why don't you give a list to the registry and ask them not to list the matters?
Sir, Lordship, we need to file reply, Lordship.
So wait for your turn.
You see, then I have a small prayer, Lordship. May kindly allow us the matter to be taken up through RVC, Lordship. Small prayer, Lordship.
That will be arranged.
Highly obliged, Lordship.
Yes.
Lordship. It's a listing of our hospital, Lordship. It was earlier listed on 1/9/25. Next week, Lordship, 2nd February.
2nd February.
Or hospital, Lordship.
All right.
May I please, Your Lordship? I beg to mention one WPC matter for listing in admission column. Lordship, kindly list the matter on 10th of February.
Not 10th, 11th.
May I please, Your Lordship? I beg to mention one listing for withdrawal, Lordship.
Withdrawal.
Yes, Lordship.
27.
27. Give your Lordship.
Wait, please, Lordship. Lordship, I beg to mention for listing, Lordship. Lordship, the matter was last listed on 24/05/2024, Lordship. Therefore, can we list the matter, Lordship? On
13th. 13th February.
May please, Your Lordship. I beg to mention 3 writ petitions, Your Lordship, which were previously listed in the month of November.
In the month of?
November, Your Lordship. Your Lordship, this is a writ petition for remission release, Your Lordship. The SLRB would be sitting in the coming weeks for the consideration of premature release, Your Lordship. So can it be on any day next week, Your Lordship?
Next week.
Oblige, Your Lordship.
May I please? Not to eviction matter, may I permitted to move today itself, Mother?
Yeah, this is like opening a shop for eviction matters.
Not
done like that. So you come
23rd
back next week. You file it. Come back next week. We'll see.
we have filed yesterday, my lord.
So let it be listed next week.
23rd is the my lord, date for eviction.
Can be helped. Can be helped. Can be helped. You file it, you will come next week.
It has been filed yesterday.
So you come next week.
Can it be on my lord, Monday?
Monday,
No,
you
no,
come
sorry,
and do it yourself.
Tuesday, my lord.
28.
Tuesday, my lord.
28.
Oblige.
Yes.
This matter was kept for instructions from the bank. I've taken instruction, my lord. This petitioner's account was, my lord, subjected to a debit freeze following multiple complaints from the cyber cell authorities. Now, my lord, I'm instructed that his disputed amount is correct, 38,000 only. Transactions are many, but amount is that only. So, my lord, lordship may perhaps dispose it off with the direction to us to keep the lien to that amount only. There is an order at page 28.
27, my lord.
28.
Please.
Page 28, my lord. Relevant portion, page 29.
Yeah. So this is up to 38,000
Lordship.
or may rounded off to 40,000. Let us.
Lordship.
All right. Suppose it is page 28, 29.
Only
Yeah.
name of bank will be changed, my lord. Name of bank will be changed.
Name same.
No, no.
No.
Defined.
Name, account number.
This is Bank of India.
Bank of India. Changsari.
Changsari branch.
Transfer branch.
Account number so and so. All right. This book.
Lord, forgot.
May I please your lordship?
Yes.
My lord, in terms of the previous order, which was passed by my lord in this matter, my lord may kindly have the previous order and the paragraph 5, my lord. In terms of the directions passed, my lord, we have received the report from the Labor Department, and thereafter also a reply has been filed on 19th. So, my lord, nothing survives in this petition. And we have already submitted our reply on 19th.
Yes.
Lordship, we have furnished the report as per the last order. If Lordship wants, Lordship can have a copy of the same.
No, we don't want. Heard counsel for parties. Petitioner before this court had received the show cause notice dated 19/12/2025 issued by Assam Legislative Assembly Secretariat, whereby the authorities concerned proposed termination of the contract of petitioner number 1 and recovery of the alleged amounts for feature of the security deposit and initiation of blacklisting proceedings. The petitioner was agreed that these proceedings was initiated without, on the basis of a report by the
Assistant Labor Commissioner.
Labor Commissioner Guwahati, copies of which were never served on the petitioner prior to issuance of the show cause stop. Accordingly, the petitioner approached this court by order dated 5/1/2026. The respondents were directed to serve a copy of the report of the Assistant Labor Commissioner on the writ petitioner within 2 working days, and thereafter petitioner was permitted to file his reply to the show cause stop pursuant to the said order. Paragraph. In deference to the said order, the copies of the report have been submitted and the reply also has been furnished by the petitioner. So, under such circumstances, since the grievance of the petitioner stood redressed, no further cause survives in the writ petition. Accordingly, writ petition stands closed at this stage without issuance of any further orders. The interim order passed earlier. The order dated 5/1/2026 stands merged. Writ petition accordingly stands disposed of.
Deeply.
Item 17, Lordships, I have received one telephonic instruction, my lord, that no application has been submitted by the petitioners, Lordship, till now.
Okay.
So yesterday or
We have
tomorrow,
submitted.
tomorrow will be the last date, 23rd is the last date.
You want to submit, you submit.
And even then, Lordship, my lord, that as part of my lord, that paragraph number 2 of the writ petition, the petitioners are for the tenant of the one Srimati Gitarani Sarkar, or her, the land, the Dag number of the land is, my lord, the 148.
Hmm.
And Pata number is Lordships 38. And the notice was been given, the Dag number 150, Lordships. 150. It is the my lord, government land,
150.
150.
Where is the notice?
Notice is Lordships, and is, see that page 16, 17, Lordship.
Page 17 first.
Vernacular is page 18.
Tag number 150.
Lordship.
We'll close it with a direction that if the persons occupying in the plot of land covered by Dag number 150 wants to file any representation along with documents, they may do so, but these petitioners do not reside in 150.
They are in 148.
So government will proceed to take steps only in respect of Dag number 150 as per the notice.
Yes.
Huh? Heard counsel for parties. Petitioners claim to be tenants of Gitare Sarkar, who is a patadar land, who is a patadar of land measuring 7 bighas, covered by patta number 38, Dag number 148 of village Oraiya Pahar, under Boitamari Revenue Circle District, Bongaigaon. According to the petitioners, they part of the land measuring 2 bighas are under their possession, and over the said land, various business establishments have been constructed, including grocery shop, as tenants of the landlord of the patadar. So the petitioners have been paying monthly rent to the patadar or the landlord in terms of the agreement. Stop. The petitioners are aggrieved by a notice dated 8/1/2026, whereby Circle Officer Boitamari Revenue Circle has issued eviction notice, has served the eviction notice on the petitioner, asking them to vacate the scheduled land on or before 23/1/2026. Otherwise, the petitioners would be evicted from the said land covered by Dag number 150. According to the petitioners, their establishments are on the plot of land covered by Dag number 148 and not on a plot of land covered by Dag number 150. Under such circumstances, the petitioners had approached this court apprehending that notwithstanding the eviction notice being issued showing the land particulars as tag number 150, on which the eviction is sought to be carried out, the authorities may proceed to evict the petitioners who are tenants in land covered by tag number 148. Mr. J. Henry, Clerk of Council for the state, was permitted to complete his instructions yesterday, and the matter was directed to be listed today. Today, when the matter is listed, Mr. Henry, on instruction, submits that on instruction submits that the authorities are proceeding to evict unauthorized occupants from the land covered by tag number 150 as per the notice. And therefore, the petitioner's apprehension is without any basis. Mr. Mondal, counsel for the petitioner on the other end, submits that if if the authorities do not proceed to evict the petitioners who are tenants in the land covered by tag number 148, then their interests are well taken care of. Considering the submissions made at the bar and upon perusal of the petition, and also upon perusal of the notice dated 8/1/2026, it is seen that the notice is addressed to persons asking them to vacate the government khas land covered by tag number 150 at village Korea Pahar. The petitioners admittedly are not occupants of land covered by tag number 148. No, sorry, 150. And the notice is also not in respect of eviction of unauthorized occupants from land covered by tag number 148, on which the writ petitioners claim to be under their occupation. Stop. In such view of the matter, the court is of the considered view that the writ petition be closed at this stage, directing the respondent authorities to strictly proceed in terms of the notice dated 8/1/2026 as per provision of law in respect of land covered by tag number 150 at village Korea Pahar. Stop. The authorities will ensure that the occupants of any other tag number other than tag number 150, which is claimed to be the government khas land, shall not be evicted without due process of law.
All right.
Let's go.
18. May I please, Lord? My lord, this is a petition, my lord, where the petitioner, my lord, is a resident, her house has been, my lord, partially, my lord, demolished by the municipal authorities, my lord. And my lord, the action of the municipal authorities have been, my lord, instigated by the private respondents for the purpose of settling their private land disputes with the petitioner, my lord. If your lordships kindly come to page number, my lord, 71 one, my lord. Seventy-one, my lord, is a legal notice issued, my lord, at the behest of the private respondents to me. To my lord, their counsel, kindly note the name of the counsel, my lord, at the left-hand top corner.
Why is the name relevant?
The name is relevant because, my lord, if your now lordship kindly comes to page number 73,
Hmm.
that is the letter which was issued to me, my lord. There in the first line, your lordship will see, my lord,
Hmm.
that a letter has been received from the so-and-so, that is the same name, my lord, of the council, my lord. So, my lord, what has been actually done is, my lord, that to settle the private land dispute, my lord, my house has been demolished, my lord, and the petitioner is an old lady of around 78 years. She lives
House is
alone. my lord.
demolished.
Partially demolished, my lord. Partially demolished. I am still residing there. But the intention of the private respondents is to, my lord, get the house demolished through action of the municipality, so they can show, my lord, that there is a color of some legitimacy there, my lord, and thereafter grab my lord, lawfully possessed and owned lands, my lord. And that is the matter for which I am before your lordship, my lord, to kindly protect me. Because, my lord, as per the provisions of even section 337, there is a reported case of this High Court, my lord, where it says that, my lord, when a house, my lord, has been assessed, my lord, by the municipality, and, my lord, a period of 3 years has elapsed, then the power of demolition is, my lord, barred by limitation, my lord. Lordship, feel, my lord, kindly see this judgment.
Management placed the judgment of Warren Sumar. This has been overruled by a division bench. My lord.
All right, but let us understand what has happened. Why have we demolished the house?
My lord, lordship will see page number 74, my lord. This is the first so-called notice. Notice was page 73 is the basically a document action notice. Thereafter, lordship, page 74 is the 337 1 and 2 notice was given.
When was the house constructed?
It was constructed, my lord, before application of the Assam Municipal Corporation Act to that areas, my lord, in Daranda and Beltola, my lord.
Then
It
what
was a
is the-
small house, my lord.
Then what is the process for regularizing?
Now, what is the 337? There is a process, but even then, my lord, as on date, my lord, if your lordship turns to their own letter, my lord, page number 76 in subpara 2, last part. As per my knowledge, land was purchased and not under GMC at the time of such. We did not apply for house construction permission. As on date, there is no NOC for that particular house. Even then, my lord, this
But you are collecting.
assessment had to be done, my lord, because this is they are within the jurisdiction of the GMC.
That's right. You are assessing for what purpose?
For revenue purpose, for the this
So
all
why
this
is collecting revenue from an illegal construction?
all this garbage and all this street lights, roads are there. They are enjoying all these things. That's why the revenue is collected. That will not regularize their unauthorized construction, my lord.
No, if it is unauthorized, then you can't collect.
No, they are enjoying the benefits of GMC. But that's why we're
They are enjoying is one aspect, but you are collecting. On one end, you are saying this is illegal construction, demolition. On the other end, you are making assessment and collecting it.
assessment will not regularize their building. But it's a
not
fact that they are within the jurisdiction of one. That's why assessment is.
No, it will not regularize. But firstly, when did you come to know that it was illegal construction?
Well, as per document, there is a complaint, my lord. That's why. my lord.
That complaint is raised by whom? On what basis have these complaints been raised? On respect of a house which was constructed 20, 30 years back. Why would suddenly somebody, I can understand that you are taking a survey of the area and you find that this
that is not
particular
possible, my
house
lord.
did not have proper documents.
Each and every house, my lord, where there is NOC is not there. That is not possible, my lord, because
That's
only
right. So you are welcome to entertain complaints, but should you not lift the wheel and look into the source of the complaint? Why this complaint has come after all these years?
even
For what purpose?
my lord, before it's page number 73. Even before acting, there is a document action notice is there.
No, that's right. But
Otherwise, this may be a frivolous complaint, my lord. We will not act it.
no, that is okay. But you must find a way to regularize it now.
They let them come up with the application, my lord. At the same time, my lord, this land, my lord, I have seen the document that this land is not the purchase of land is a possession, not even registered. That's the difficulty on his part, man.
That's a different matter, my lord. Ultimately, it's Pata land, my lord.
We'll issue notice today.
Lots will issue notice.
Right,
Kindly, my lord, stay further, my lord, demolition which I apprehend.
Mr. S. Bora.
I appear for respond number one,
Counsel appearing for the GMC, except appears an exception of please on behalf of respondent 1, 2, 3,
my
4.
lord, not two, my lord, 1, 3, and 4.
1, 3, and 4. Who's for 2?
Two government is there, my lord. This is the director of municipal.
Who's for the government? Who's the state council here? Any state council?
My Hendik was there, my lord, just now.
All right. Mr. J. Hendik, that comes in for the state. As such, notices on behalf of respondents 1, 2, 3, 4 away. However, extra copies we furnish. Steps on respondent 5, 6, 7, and 8
Yes,
by registered post 80. Registered post within 1 week from today. Let the respondents complete their instructions and file necessary affidavit. And the GMC authorities will not proceed.
Well, even the Lordship will come to the pair, my lord. There is no interim pair also. Page number 35 and 36.
Has it been demolished?
It has been
Partially,
demolished.
partially,
His
partially.
own statement is partially demolished. There is no interim pair.
My lord,
Pay all further proceedings.
my lord.
GMC authorities will not proceed for demolition of the house. Does the house have a number or something? No.
My lord, house number 1, Rashmi Pot.
So where have you written in the schedule? You have given the description of the land only.
Yes, my lord.
House number 1.
In the prayer
Rashmi Pot, Chandan Nagar VIP near so and so, page number 36.
Yes, my lord.
Pursuant to the notice and proceedings initiated. Let the matter be listed again on on 18. No, 18. So no demolition till 18.
And the profession.
This matter can be fixed on 28, Wednesday, Lordship.
On the request of the counsel for the petitioner, matters that is referred to listed on 28th of January.
20.
We have passed some orders yesterday. There is some letter issued.
Yes.
So in view of that, the eviction process will not be continued.
Joint
Well-
verification is necessary, no?
Huh?
Joint verification.
Everything is there. You go through the order, we'll pass similar orders. That would be the order.
Oh, okay then.
But counsel for parties, huh? Similar order to it. Do you have an extra copy you can give me?
Very well. I'll get it.
You go through the order.
Public.
21.
Yes.
My lord, the petitioner, my lord, the purchased Erekanus, my lord, which were moving in transit, my lord. And when the goods were in transit, the same vehicle was detained by the officers. And after detaining the vehicles, my lord, the officer, my lord, purportedly made a payment of the same. And it was found that about 700 kg or something was sold.
And that was for the reason, my lord, that it was taken along with the weight was taken along with the bakes. Now, all the documents and papers in support of the Eric Anners were available, EVA notes, invoice, everything was available. Now, the authority concerned has gone that it was undervalued. Now, on the basis of the undervaluation, that purportedly that the undervaluation was there, the authority has imposed the penalty and the tax demanded. Now, it also can I see section 129. Kitab diya.
Yes.
One 129 what? 129, you know.
Yes.
Notwithstanding anything contained in this act, where any person transports goods or stores any goods while they are in transit in contravention of the provisions of this act or rules made thereunder, all such goods and conveyance and so for carrying the same goods and documents relating to the goods and conveyance shall be liable to detention and seizure, and the detention of the seizure shall be detention and seizure shall be released. Now, you also may see this is a provision of the contravention of the act. Now, the contravention of the provisions of the act, my lord, means the same are not supported by the proper documents and papers which are provided for in the act. Now, whether for undervaluation, my lord, the goods can be detained or not, this has now been settled by the various decisions, including, my lord, the decision of this honorable court. Yes. This was in the context of, my lord, Assam General Sales Tax Act, where the calamity provisions were there. You also can see page 430.
Yes.
The fourth or fifth line, my lord, in case of the registered dealer.
Hmm?
At 430, my lord,
430,
fourth line, my lord,
fourth line.
fifth line, in case of a registered dealer.
Yes.
In case of a registered dealer, if the total quantity of goods stock in transit are identifiable and variety thereof is known, to hold the goods are not properly accounted for merely because there is a difference in the opinion as to the sale price thereof, is considered view of the court, it would be doing violence to the scheme contemplated by the act. Not only that, it would be inherently dangerous to read any such conferment of power at the stage of seizure in view of the possibility of abuse and misuse, and it would be far more reasonable to understand such a conferment of power to have been made by the legislature at the stage of completion of the quasi-judicial act of assessment, when effective remedy can be attempted at the stage of final assessment, and the object of the act, that is, to ensure due and proper collection of tax, can be achieved at the stage of assessment, there is no reason why by the process of judicial interpretation such a power should be conferred on the authority at the stage of seizure. The power to determine the sale price for the purpose of assessment of the tax of the act in the case of dispute, therefore must be understood to have been vested in the assessing authority, and insofar as the registered dealer, like the writ petitioner, is concerned, if the quantity of the goods in transit and the variety of thereof is known, what should be the sale price for the purpose of assessment of tax is a question that must be understood to have been delegated to the statute to the extent of final assessment. In conclusion, that appears to be the fortified by the provisions contained in so and so. In view of the following discussion, this court is of the come to the opinion that the total quantity of the goods in transit and the variety of thereof is known, merely because a dispute has arisen with regard to the value of the goods sold, would not bring the situation where the petitioner can be said to have not accounted for the goods in the transit. Now, in this case, you'll also see into a SOCOS is the SOCOS notice which has been issued to me, look,
Next 15, 160.
at page 116.
One six zero.
160, Milo.
Hmm.
You also got in, Milo.
Yes.
Well, in the bracket portion, Lordship, you can see goods so and so in excess of the invoice quantity was found. Quantity of goods as per invoice 30,870 kg. Lordship, got it,
Hmm.
Then quantity of goods as per physical verification 32,180 kg. Quantity of goods not covered in the invoice number 1310 kg.
Yes.
Now, the payment was not made in possession of the petitioners. Secondly, the payment is of the actual occurrence in nuts, not along with the bags. The difference which is coming is not of the stock of the goods, but because of the goods were weighed along with the bags. Now the bags is there, then the payment will be different. But you lost further similar. In view of the above, the goods and conveyance used for the movement of goods as detained under so-and-so of the Act, read with section so-and-so and section so-and-so of the integrated so-and-so, I made it over. Part of the goods of 30,000 kg were covered under invoice number so-and-so, number GST number so-and-so, so-and-so. So 30,000, he's saying that it is covered by all the papers and documents. Now,
No, that is reflected here in the particulars.
my lord, particular, but he's mentioning that it is all covered, my lord.
Oh, he says covered is 30,870.
My lord, my lord. Now we're also going to see the last three lines. Based on the seized evidences recorded during a search of the physical premises of the business of so-and-so company, it was found that the procurement rate of the goods by the so-and-so is so-and-so rupees kg. However, the rates of the goods quoted in the aforesaid a copy of the rupees so-and-so kg. It appears so-and-so. A lordship sees the para 7. As discussed about the good so-and-so were transported by grossly undervaluing the value of the goods supply. It is presumed that the goods in vehicle were being transported for a purpose of evading the taxes in view of the understand promises so-and-so. Now, on the basis of the fact that it was on the basis of undervaluation, the authority has detained the goods, and the tax element you'll also kindly see at the bottom, second part at the bottom, 1,80,799. As you also got at the bottom.
Yes.
And on the next page, you'll also can see
Yes.
3 million.
Yeah.
Is determining the penalty in respect of the SGST 36 lakhs, fine amount 36 lakhs.
Yes.
Got it, my lord. Then calculation of the fine in lieu of confiscation is saying, my lord, 1,80,000. And the bottom you'll also see, my lord. Calculation of penalty 3,61,000. Calculation of fine 72 lakhs. Calculation of fine so 3 lakhs 79,55,000. Now, according to him, my lord, the tax amount is 1,80,000. Now, what he has done, my lord, the total value of the goods which were there in the vehicle, that is entire value, my lord, 30,870. He has taken the valuation of the entire for the calculation of the penalty, confiscation, and all those things. Whereas, my lord, the penalty cannot be imposed. You're also going to see on section 129(30) itself. Para 64, my lord. This is in respect of section 129 and 130 of the Act.
Yes.
May I read, Lord? 64.
Yes.
In order to invoke the severe action of the conspiration of goods and conveyance during the transit, the contravention infringement has to be of the highest degree such as absence of documents or fact of false documents, absence of detail of dealer, forged e-way bill, and a complete discrepancy, divergence, mismatch of the goods, fake registration, etc., which apparently specifies the intention to evade taxes. We may also clarify that the proper officer cannot venture into the assessment and valuation of the goods at the time of interception of the goods vehicle and resort to seizure and confiscation of the goods and conveyance and reasoning to the entries in the portal and digging out the evasion of the tax, etc. So what is contemplated in the section 129 is, that documents are forged, the registered dealer is not there, invoice is not there, and all those things. But the authority has no power to determine the value of the goods at the check post. He can at best convey the message to the adjudicating authority. But the assessment cannot be done at the check post. He is not the proper officer. And this is under section 129(30) of the Act, 130 of the Act.
Let us come to 129 again.
129. My lord. May I read once again, Lord?
Yes.
Notwithstanding anything contained in this act, where any person transports any goods or stores of any goods while they are in transit, in contravention of the provisions of this act or rules made thereunder, all such goods and conveyance used as a means of transport for carrying such goods and documents relating to such goods and conveyance shall be liable to be so be detection. Now, contravention of the provisions of the Act, my lord, the provision says that these are the documents which are to be carried. And they are all with accompanying with the, my lord, the vehicle. With the authority himself is admitting that all the documents were available.
But it gives the power to proceed for imposition of penalty also.
Well, the power to imposition of penalty is there when below the first subsection is violated. If subsection 1, there is no violation, the question of imposition of penalty does not arise. Only when the goods are moving in contravention of the provisions of the Act and the rules.
So according to them, that particular 3,000 or whatever kilograms
1,000
was not covered by, or
well, the goods which are there, the bags are there. The bags which are there, the bags are telling. Now, he said on payment, I have found the sort of this one. But this is not a ground on which he is imposing the penalty. He is imposing the penalty on the ground of undervaluation. Assuming, for the argument's sake, their contention is accepted. Then also, what is the undervaluation? The mismatch, 3,000 something?
1,300.
1,300, that can be only shortfall.
Right.
Now, how he can take the entire value of 30,000 for the purpose of imposition of the penalty? He's doing on the basis of undervaluation, which is not permissible at all. In fact, no tax is leviable. No tax at all is leviable, not to speak of the penalty. Under similar circumstances, my lord, when the goods were seized, and that was a subject matter of challenge, my lord. This honorable court required 10 million.
Yes.
Otherwise, my lord, on the road, every officer will start making the assessment. Fully covered by the judgment of this honorable court, my lord, that there is no such power. And it will be very dangerous if such a power is read in the provisions of the Act. The goods which are there, they are perishable. And in fact,
What has happened to the goods?
They are lying there, my lord, in the vehicle. Although no tax is payable at all, but even then, my lord, I am ready to give a bank guarantee of the tax amount. But where the question of imposition of penalty, the condition is not fulfilled at all. He is proceeding on the undervaluation on which the power is not there. The Gujarat High Court has clearly held, my lord, in reading the section 129, 130 of the Act, that such power is not there. One cannot do it.
Yes.
Secondly, my lord, I requested for supply of documents and papers to me for giving a reply. That has not been also supplied to me. That has not been referred to, my lord, in the documents and papers. You'll also may kindly see although it is not necessary, you'll also be well aware, the decision of the Supreme Court, my lord. Yes. All the documents present in the copy there. It will. Para 15, my lord. Last 4 or 5 lines.
Yes.
A person charged with the misdeclaration is entitled to know the grounds on which he would be penalized. He may have answer to the charges or may have, but there cannot be any doubt whatsoever in law that he is entitled to a proper hearing, which would include supply of all the documents. Only on knowing the contents of the documents, he would be furnished an effective reply. And one more judgment, my lord, for my satisfaction, my lord.
No, this is all right. There's no need.
No,
for
on that,
further
another
judgment.
issue, my lord. I will come to High Court again. At para 8, my lord. The last, third page, my lord, at the top. Upon query made, the Learned Standing Council could not dispute that at present that the revenue has not formed any opinion to falsify the genuineness of the tax invoice or e-way bill claimed by the petitioner. It also does not dispute that those documents were found present on the vehicle in question at the time of his first detention. It is further not in dispute that the petitioner claims to be the owner of the goods. Accordingly, the petitioner may remain liable to pay the security in terms of section 129 1A of the Act. Question of penalty, my lord, when they come to the conclusion, my lord, that the documents and papers which were produced were forged, the documents papers were not there, then only, my lord, the power in the 129 will arise.
Yes.
Lordship, page 161. This is Lordship, only notice, Lordship. Paragraph 7. Page 161. Merit, Lordship. Page 161.
Yes.
As discussed above, the goods, dried areca nuts, were transported by the grossly undervaluing the value supply. It is presumed that the goods in the vehicle were being transported for the purpose of evading the taxes. In view of this, undersigned is proposed to confiscate the above goods and conveyance used for transport of such goods under provision of section 130 of the Central Goods and Service Tax, read with provisions of the State Goods and Service Tax in so and so so and so. Now, Lordship, may come to page 163, paragraph 9. You are hereby directed to so cause within 7 days from the receipt of this notice as to why the goods in question and the conveyance used for the transport of such goods shall not be confiscated under the provision of section 130 of the CGST Act or Integrated Goods and Service Tax and Goods and Service Tax Compensation to States Act 2017, and why the penalty and other charges payable in respect of goods and conveyance shall not be payable to by you. You are hereby directed to appear before undersigned on 30/12/2025 at 11 AM. Lordship, the notice was issued on 22nd of December. Now we are in Lordship.
What happened on 30/12?
We gave a reply.
Lordship, they sought for some documents. Lordship, may I please to see come to page 175.
Page?
175.
Yes.
they asked for some documents, then clarification was issued by the department. Subject petition to provide copies of documents relied upon certain other details in connection with MOV G10 notice issued. Please refer to your letter dated 24/12/2025 and 30/12/2025 on the subject cited above. In this regard, it is informed you that the particulars requested by letter dated 24/12/2025 and 30/12/2025 at serial number 1 to 3 of, of the table were already provided to the driver person in charge. Copies of the same being provided herewith as requested. Further, it is informed you that the other particulars as mentioned in serial number 4 to 10 were not relied upon while issuing MOV 10 notice under dated 2012/2025. It is also noted that you neither appeared in person on the scheduled date of personal hearing nor have submitted any written reply to MOV 10 issued. Copies of the MOV so along with so are enclosed. Therefore, the personal hearing is once again scheduled on 16/1/2026 at 12 p.m. and you are requested to appear before the undersigned at the office of DCGI Guwahati so, following which the issue will be decided ex parte without any.
Now,
further
what has happened on 16 again?
They didn't appear, Lord.
180 Your Lordship, page 180.
They didn't appear, Lord. They are asking for some documents again, Lord.
Hmm.
Then again, they file application shouting some that these documents were relied by the department. So they are.
There are the documents which the department says that we are not relied on. We have given a chart that where it has been relied on. Your Lordship, kindly see me, Lord.
Hmm.
That where the documents have been relied on. We have given a chart of that one.
Yes. Now these documents have not been furnished.
These documents are not being furnished.
They stated that they relied on the serial number 1 to 3 only. That will supply to other.
We have given a chart where it has been relied on.
And that's page 183, they asked for further time to refix the personal hearing of our case only after making available as the documents as prayed for. They are sticking on the documents from serial number 4 to 10.
Without documents, how we are.
As per my instruction, Lordship, as stated in paragraph 183, the document serial number 1 to 3 has already been provided to them.
They want some additional documents. Why not?
Not, this is Lordship available on the record. Personally, instruction, I have to take instruction, Lordship.
You take instruction. Huh?
Lordship.
Let him take instructions to find out when the documents can be provided. If it can be provided, you go and appear and argue the matter.
Well, I
Mean-
have reaction once the so-called reply is to be given. If the documents are not available, how I can be supposed to give a reply?
No,
to-
that's right.
Ma'am,
So let him obtain the instructions, whether these documents. When can you get it?
Tuesday, Lord.
Tuesday. Let it be on Wednesday. 28th.
Lordship.
All right. Heard.
in the interim, on furnishing of Bengal, the goods must be released.
We'll consider it on Wednesday.
Your Lordship, kindly see me, Lord. The judgments on the point on this Honorable Court as well as that one, and we are giving a bank guarantee of the tax amount.
No,
Yeah.
quite all right. But let him first obtain these
So
instructions.
this instruction is only about the documents to be furnished.
Correct.
This is not about anything else. This is about the documents to be furnished for furnishing a reply to so-cause.
That's right. So let us first find out whether they're in the position to supply you or you.
Even if assuming they are not in a position to supply,
Huh.
they are not in a position to supply that, they will not be able to supply. At best, what can be there without documents, I will say that my prejudice to my rights, I will submit reply, that's all. But that will not make the seizure detention legal.
So that will determine it. We are not closing it.
My Lord, in my humble submission, my Lord, when
Yeah.
furnished a bank guarantee in the earlier order also, the goods cannot remain, my Lord, that there. My Lord, what harm will be caused to them? That if the goods are released and the penalty, if it's there, it will be payable. Your Lordship may record it. That ultimately, if it comes to the conclusion that penalty is leviable.
Mr. Kial has asked for a short date.
Look, KL is asking for a short date to find out whether documents can be supplied or not.
Correct.
I'm not on that issue at all.
Huh.
I'm on the issue of the legality of the detention.
No, but if the documents they're supplying it to you,
My Lord.
you are duty bound to.
Did you supply, but that will not make my Lord, the seizure to be legal.
That will decide.
My Lord,
That will decide on that.
My Lord, in my humble submission,
Huh. But if we decide the seizure to be illegal, what is left to be
my
decided?
Lord, if your Lordship can see, my Lord,
What for are you going to furnish a reply?
if your Lordship, my Lord, the goods which are lying, if I'm giving the bank guarantee of the tax amount, why the goods should remain in detention, my Lord? That's my humble submission,
That's
my Lord.
correct. But let us wait till the next Wednesday.
As your lordship pleases, my lord.
Let him get the instructions.
Lord, his instructions,
We'll pass
you-
orders on that.
with due respect, the instructions are only for documents, and the instructions are not on the merit of the case. Whether documents can be supplied or not,
No. One of your grounds, one of your arguments is that in the absence of these documents, you are unable to
no,
submit
that
a
is only
reply.
for the so-called reply.
That's right.
But that is not on the ground of the detention illegal and the valuation.
And what do you intend to do with these confiscated goods?
But say that will be auctioned if it is confiscated,
Uh,
the reply is submitted.
so why don't you release it on the basis of bank guarantee?
It's
In the earlier order also, when it has been released on bank guarantee,
You release it on bank guarantee.
Lordship then maybe taken away at 2 PM, Lordship, in the meantime.
All right.
at least the goods may not on the furniture bank guarantee tax amount, that can be released.
Lordship may take away 2, in the meantime,
All right, at 2 p.m.
23 is similar, my lord.
All right.
May I please, Your Lordship? This petitioner is agitating the issue of the high-net action on the part of the respondent number 5, the concerned officer in charge of the police station and the circle officer. What has happened in this case, Lordship, the petitioner is the absolute owner of a plot of land, it's a patta land. And adjacent to that, there is a actional land which is also
Have you
under
filed it before the authorities, revenue authorities?
Lordship.
Have you filed your complaints before the revenue? authorities?
Exactly, Lordship. I've annexed all the documents, Lordship.
Oh.
This is at page number 26 is also there, Lordship, the circle officer. 29, Lordship, sorry, 29. This is the communication to the commissioner of police. And 31 is the before the concerned circle officer. There's a civil suit is pending with regard to the Patta land, Lordship, and the injunction order is in force. I have made a specific mention that since the injunction order is there, there is no scope for demarcation, and the police is not supposed to demarcate the land. And more to that, Lordship, when the complaint is one purported complaint has been filed, I am supposed to get the copy of the complaint. Nothing.
Mr. Hendik,
Lordship,
any instructions you'd like to get?
Lordship. Some time may be granted, Lordship. I will take instructions.
And by the period of time of Lordship on 7th of January, with
Hmm.
the assistance of the police, Lordship, they have encroached over my plot of land. They've demolished my entire boundary wall, they've entered into the plot of land and they've demarcated the land when the injunction order is there.
So why did you not approach the civil court?
Lordship, civil court suit is pending, Lordship. I filed an application for violation. But the
No,
thing is
if
that
the injunction order is violated.
exactly, Lordship, I filed an application for violation. But the thing is that since the concerned court is saying that you don't have any copy of the complaint, I have no paper, Lordship. How they have acted and why they have acted, at least some notice should be served upon me, at least with regard to demarcation. Repeatedly, I have urged upon the concerned authorities, provide me some document so that I can give response. Nothing has been provided to me, Lordship. Because demarcation, police cannot go for demarcation. At least if someone is claiming any right over the land, he has to file an appropriate application before the concerned authority. That has not been done. I went to police is saying from the circle officer, I went to circle officer saying from the police, I got the information. So everybody is shifting burden to one after another, Lordship.
Heard counsel pro parties. Mr. J. Hendik, Government Counsel will obtain instructions in the matter. List on
Thought that may be given, Lordship. There is some
30?
addition.
30.
30, Lordship, it is difficult to.
Why difficult? Only instructions as to what is going on there.
Pattashil Lambari Police Station, Lordship.
You furnish extra copies. today
Exactly.
itself.
I will do it today itself.
Yes.
Obliged, Lordship.
24.
Yes.
May it please, your lordship.
Yes.
These petitioners, they are all, my lord, on licenses of IMFL. Lord, they are agreed by a series of notices, my lord.
Hmm.
If your lordship would kindly come to page 75. Whereas I am satisfied on the basis of the information which has come into my possession that you have been liable to payment of tax under the Assam value-added tax in respect of the period commencing on 1/4/22 and ending with 31/3/25,
but have failed to apply for registration, thus you have rendered yourself liable to be assessed to tax for the aforesaid period and also liable to imposition of penalty under section 26 of the Assam Value-Added Tax Act. Now, what had happened, my lord? In some of the cases of on-shop, what has been issued, only a direction to get registered. In our case, they say in addition to the registration, we are also liable to pay the tax assessed as well as penalty. Now, my lord, my respectful submission is, my lord, this entire notice is without any jurisdiction. First of all, to appreciate my case, my lord, if your lordship would kindly have the VAT Act for a moment, my lord. এখন আছে নে? এখন আর আছে না নাই বা? আছে? First, my lord will kindly come to section 21, my lord.
Yeah.
Registration of a dealer, amendment and cancellation of registration certificate, etc. Compulsory registration of dealer. No dealer shall, while being liable to pay tax, carry on business as a dealer unless he has been registered and possesses a certificate of registration. To put it very simply, my lord, if there is a liability to pay tax under the VAT Act, then there is a requirement of registration. If there is no liability to pay tax, there is no question of registration. Now, please come, Lord, please come to 4th schedule of the Act.
Yes.
Now, kindly look at the heading, my lord. List of goods taxable at the point of first sale in the state. Now, please come to entry number 10. Foreign liquor, whether made in India or not, including brandy, etc., etc. So, my lord, IMFL is liable to be taxed at the first point. Now, lordship knows under the earlier rules of 1965, the taxable event was the event when the IMFL leaves the bonded warehouse. Once the goods leave the bonded warehouse, then it becomes duty paid. We defect from 2016, my lord, when the rules were framed in 2016 to effectuate the purposes of the 2000 Act. Now there is a concept of warehouse also. Now for that, if your lordship would kindly take the excise action division.
State.
Assam, Assam. One year, na?
Yes.
Rules. Yes. My lord will kindly come to the rules, my lord. It will be 1 capital A, Roman 16 and Roman 17. First, I'll refer to the definition of bonded warehouse. Bonded warehouse means the premises or any part of the premises within a manufactory or within the canteen store depot approved and licensed for deposit or storage of spirit on which duty has not been paid. Now kindly come to 17. Wholesale warehouse means the premises or any part of the premises approved and licensed for deposit of storage of spirit on which duty levy has been paid and from where Indian made foreign liquor may be supplied by the wholesale. Now, my lord, under the present legal regime, the goods from the manufactory, it goes to my lord warehouse. It doesn't go to the bonded warehouse. And the warehouse pays the tax, my lord. Now, on this consignment, they pay 19.27, na? 25%. The warehouse keeper, my lord, he pays duty, tax, everything including, lordship knows, my lord, excise duty and VAT, though these are independent duties, but both are, my lord, intrinsically, connected, because end of the day, my lord, we are selling at the MRP. And in the MRP, my lord, excise component and the VAT component is already included. Now question is, if liquor is a good which is subject to levy at the first point of sale, first point of sale is the once when it leaves the warehouse. Now where is the question of, my lord, now where is the taxable event? Lordship knows, and in this Saturanandan's case, Honorable Supreme Court says there are 3 stages in a taxation. First, there is a charging provision. Here the charging provision is section 10A, I'll come to it, my lord. Then comes assessment, third comes recovery. So without there being a charging provision, how can you demand of us to be registered and pay
Where
tax?
is the demand made?
That's the second part, my lord. Second part at page 75.
Oh. So this is this is on the.
See, my lord, which are considered and ending on, but have failed to apply for registration, thus you have rendered yourself liable to be assessed to tax for the aforesaid period. Well, I have demonstrated section 21, my lord, which clearly says when there is a liability to pay tax, then only question of registration comes. I buy duty paid goods because wholesaler has already paid. Wholesaler has paid 19.25% of duty. And my lord, kindly come to section 14 of the VAT Act for a moment, my lord. This also makes the position clear. Section 14, my lord.
Yes.
At yes. Kindly see, my lord, section 14. Subject to other provisions of this section, any registered dealer who makes purchases from another registered dealer of taxable goods other than the goods specified in 4th schedule. That means, my lord, in case of goods covered by 4th schedule, since it is a duty payable at the first point, there is no question of taking any input credit. Now kindly come to, my lord, subsection 6. Clause 6. No input tax credit shall be claimed by a registered dealer or shall be allowed to him. Please come to subclause J, my lord. Tax paid on purchase of goods specified in the 4th schedule. That means, in respect of goods covered by 4th schedule, one cannot take any input credit. Idea is very simple because it is already paid. So if it is a first point sale, how does the concept of value-added tax come here, my lord? Now, what is the fundamental mistake which the state has done? That I will demonstrate, my lord. If your lordship would kindly come to the notice once again at page 175. Whereas I am satisfied on the basis of information which has come to my possession that you have been liable to pay payment of tax under so and so. My lord, my humble submission is, my lord, this satisfaction is not based on any bona fide belief. This is an absolutely wrong presumption because after 2016, the excise regime has changed. I am not collecting any goods from the, my lord, bonded warehouse. Now, another set of notice which has been issued to some of the parties.
How do you collect it from the wholesale? I mean,
No, my lord. When I buy from the wholesaler, the excise duty and the VAT component is already embedded. So I have already paid.
no. Wholesaler gets it from where?
From the manufacturer.
Manufacturer.
Yes. Manufacturer, distiller, CSD, canteens.
What happened to the bonded warehouses?
No, now that one concept is no longer there. In fact, my lord, lordship would recollect that 65 rule has been repealed. It's no longer there. So if that is the position, now kindly come to one notice, then that will make the position clear, my lord. Please come to 107. This is another set of notice which has been issued to the some of the, my lord, on licensees, where of course they have not come, just to show, my lord, what is their basis. Whereas section 21(1) of the VAT Act clearly states that no dealer shall, while being liable to pay tax, carry on business as a dealer unless he has been registered and possesses a certificate of registration. It also states that a dealer liable to pay tax shall apply for registration within 30 days from the date on which he is liable to pay such tax. Whereas as per the government notification dated 30th September 2015, this is important, an amendment of section 10 has been done by substitution of section 1A, which now reaches, kindly similar. Notwithstanding anything contained in this act, retail on license holder for potable liquor mentioned in the fourth schedule, except country spirit, shall pay output tax on the sale made by him at the rate of 6% without any set off on the tax paid on the purchase made from bonded warehouse in the state. We never made any purchases from the bonded warehouse, my lord, after 2016. We are making purchases from the warehouse which is duty paid. And it is a single point levy, first point levy. The moment it is paid, there is no further incidence of tax. Now, my lord, see this amendment. I am handing over a copy, my lord.
Yes.
Kindly see, my lord, it came on 17th June 2015. I'll have your lordship's kind attention to amendment of section 10. Notwithstanding anything contained in this act, the retail on license holder for potable liquor mentioned in fourth schedule, except country spirit, shall pay output tax on sale made by him at the rate of 6% without any set off of tax paid on purchase made from bonded warehouse in the state. So they are proceeding on the premise that we have purchased this stock from bonded warehouse, whereas we have not purchased from bonded warehouse. Yes, if you would have purchased from bonded warehouse, then maybe you would have been liable. But that regime does not exist.
No. Is it to say that bonded warehouse and wholesale warehouse have now become?
No,
So no-
bonded warehouse has become defunct, but warehouses are fully functional. Ase. Those are not duty paid. We do not buy from bonded warehouse. We buy from wholesale license. Sorry, warehouse license. So from warehouse, we have already duty paid. In fact, my lord, this honorable court had the occasion to deal with this point. 2023 3 GLR. GLT, sorry. Nine. I'm handing over the copy, my lord.
Yes.
এটা বহুত দেরি লাগছে না এখন কিতাব দিয়ে দেন Well, I'm reading it. I'll hand over the copy slowly. However, if bonded warehouse is not within the manufactory or canteen CSD, then it would be a wholesale warehouse by definition of Rule 1A17 of Rules of 2016, and deposit or storage of spirits are permissible in respect to which duty levy has been paid. In other words, the incidence of levy of duty had changed in as much as when there is a deposit or storage of spirit in the wholesale warehouses, the said spirits have to be understood that duty levy have already been paid. So, Mila, the moment we pick up anything from the warehouse, then it is Mila duty paid.
Here's a coordinate bench.
Yes, coordinate bench.
Which paragraph?
Milord, I have given some reading point is there, Milord. And on the left hand side top. Yes.
Yes, yes. Yes. What was the issue here in this matter?
My lord, my lord, in the present matter, sir,
No, in this matter.
the present judgment, sir.
Ah,
In this matter, my lord, when in 2016, when the bonded warehouse, which were earlier bonded warehouse, erstwhile, the status was changed to wholesale warehouse. They not being within the premises of our manufactory, they were asked to pay duties on their unpaid stocks on which excise duty was not paid. So BIO came and they took stock. Even though they have paid the duty, they created some kind of demand, sir.
All right, yes.
my lord, last point, my lord, if your lordship would kindly take the Abbott Act for a moment, I'll have your lordship's kind attention to explanation 2 to section 10.
Why to omit it? In 2016. The living fiction is there. Now this living fiction does not exist.
In case of spirit mentioned in fourth schedule, officer in charge of the country spirit house who sells or supplies such item to a licensed retail vendor shall be deemed to be the first point seller. So my lord, fourth schedule goods, it is the first point seller. First point seller is the warehouse, wholesale warehouse, and it is duty paid, my lord. So therefore, we cannot be fastened with any further liability to pay VAT. It's a total misreading of the, my lord, scheme of the act. It goes against the fundamental principles of law. As far as, my lord, fourth schedule goods are concerned, to levy a tax at a subsequent point is against the, my lord, very fundamentals of the VAT Act. Therefore, in my humble submission, my lord, this entire notice is without jurisdiction and is liable to be interfered with, my lord. And, my lord, subsequently also there are amendments which will clearly show, my lord, where, my lord, the only warehouse has been made liable. I have given those, my lord, notifications, my lord. If your lordship kindly comes to page number 85, my lord. Now, please come to 86, my lord. This is the amendment of 2016. Kindly see, after subsection A, which I have already read, my lord, the following new subsection B, C, and D shall be inserted. Notwithstanding anything contained in this act, in case of potable liquor mentioned in fourth schedule, except country spirit, if first sale of such item is made by a manufacturer, bottling unit, distillery, brewery, referred to as seller located within the state, the wholesale warehouse license or any dealer who purchases such item from such seller shall be liable to pay tax. Then please come to C, my lord, 1C. Notwithstanding anything contained in this act, in case of a potable liquor mentioned in fourth schedule, except country spirit, if the first sale of such item is made by an importer, wholesale warehouse license inside the state, he shall be liable to pay tax. So likewise, my lord, the act has delineated on whose liability, and it is the liability of the wholesaler. So once it is the liability of the wholesaler and it is a fourth schedule product, my lord, there's end of the matter, my lord. Where is the question of further liability being attached to retailers like us? Where is the power? It's directly violative of Article 265. Which is the incidence of tax? You are relying upon 1A. 1A speaks of bonded warehouse. Therefore, in my humble submission, my lord, this show cause notice is required to be examined. It should be stated.
My lord.
Yes.
This letter circular is if
And my lord, page 94 and 5 circular also will have to be stayed, my lord, where they have issued direction to the lower officials to comply with the notices. Page 94.
not to remove the excise license.
Yes.
Lordship, first of all, I'm raising a plea of maintainability. Lordship has seen the Annexure B series, the notices. It has been issued by different taxational authority. And Lordship, for each of the notice, the periods are different and the bases are also different. How they have combined it and came jointly, there is no statement also.
They're questioning the very source of power.
Yes, that is there, but Lordship, for each of the notice, there has to be different material on the basis of which the authorities have issued the notice. Lordship, how I can make submission when each of the periods are different, reasons are different?
No, they're primarily questioning
the source of the
power, direction for the retailers to get a registration when they are not required to pay tax.
For that,
Right.
Lordship, that I have to take instruction.
What instructions?
No, the source of power.
You show us that these are issued in terms of the powers which can be traced to the act, the rules or notification or whatever.
Lordship, because each of the authorities have issued different, on what basis they have came to the final reasoning to issue the notices.
But Leonard, Mr. K.N. Chaudhary, yes, Mr. Gogoi, anything to submit?
Yes, Lordship.
We are only asking you what is the source of power? What are the materials on which they're issuing individual show cause notice will be addressed on a separate issue. Whether
Lordship,
the only reason is that get registration. Their question is that we are retailers, we are not required to get registrations.
Lordship, that will be on the section 10(1)(a) that my learned senior has already. The main source of power is section 10(1)(a) of the VAT, Lordship.
So
That is bonded warehouse.
then one is with regard to bonded warehouse.
Yes.
Here the issue is that this retailers, when they purchase this stock from the wholesale warehouse, there they pay a VAT amount, which goes into the excise head. That amount is paid to the excise head. Now, at the point of selling, that has to be collected by the tax department. That amendment came in 2015. From 2015 till 2025, none of the on-shop retailers have registered themselves under the VAT. Now since the tax has come up, they're saying that you have to register under VAT. Till date, they have not registered under VAT, and thereafter circulars issued to the excise department saying that since they have not registered under VAT, the renewal can be done, because as per rule 128 of the renewal of the excise rules, Your Lordship. Renewal of license, Your Lordship. All retail license of foreign liquor, country spirit, heritage, alcohol beverage and other intoxicants granted under this rule shall be renewed annually by district collector on payment of prescribed annual fees if there is nothing adverse against the license and if no government dues remain as arrear with the licensees.
No, that's all right, but how do you impose the government dues? On what basis?
Similar matters which already have been taken up in the coordinate bench, Your Lordship. If I place an order, Your Lordship.
No, that writ petition have withdrawn, my lord.
No, another writ petition filed. Different writ petition, Your Lordship.
Oh, conversion.
No, that's a code.
That is with regard to conversion.
Conversion of what?
From on to off.
If I may take a Lordship to para 6, Your Lordship. On the other hand, it is further predicament of the petitioner that the respondent issued a communication directing the petitioner to register under the Assam Value Added Tax 2003 in view of section 10(1)(a) of the SATE Act, which came into effect in 17/6/2015. Learned counsel for the petitioner submits that petition license expired in 15/2/2026 and respondent authorities have taken this an excuse not to renew, although no amount of tax has been quantified for the petitioner. It is under such circumstances that the present writ petition be filed. At para 9, Your Lordship, pending the next act, it shall not be a bar part of petitioner to register under the Act of 2003 if so advised. At least let them get registered in this VAT, Your Lordship.
No,
And-
registration, first we have to show that the registration is required under the statute.
Wait for this exercise. May I take your lordship to the Assam Validated Text 2023, Rule 26, your lordship, 316, page number. 6 are the compulsory. 21.
Rule?
26, your lordship. Sorry, 21, your lordship, 21. Compulsory registration of dealers, your lordship. No dealer shall, while being liable to pay tax, carry on business as a dealer unless he has been registered and possesses a certificate of registration.
Rule number?
Rule 21.
Section.
Section 21, sorry.
I placed that, my lord, provided I am liable to pay tax. Then notice itself is on a wrong premise. ये क्वेश्चन होगा then you can do request with
Anything more?
Lordship, if I'm paid to take page 100, your lordship, of the writ petition, lordship. The same set of petitioners were filed, though they're later withdrawn at your lordship.
So
here there's clearly stated that since it's a statute, Assam Railway 2003 was made in the year 2015.
No, we don't know. That order is no longer there.
These points were not ours, that's why we have withdrawn that petition. The points which are urging presently were not ours there.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr.
PK Purohit, Bharat Purohit.
B.
Bharat Purohit.
Purohit, P.K. Purohit. There's also Mr. B. Chaudhary, Planning Council appearing for the Finance and Taxation Department, and Mr. R.R. Biko appearing for the Excise, State Excise Department. The writ petitioner, (11) in numbers, are all license holders of IMFL. IMFL on shop retail, on IMFL on retail shops. Engaged in the business of sale of potable liquor, including foreign liquor, whether made in India or not, etc. The grievance of the petitioner is that in spite of the petitioners are agreed that the liquor which is being purchased from the wholesale warehouses and after due payment of taxes, etc. And when and subsequent sale.
There's one thing, Miller. It is the wholesaler who pay. That is how it is duty paid, not we. So that is added to the value, MRP.
The petitioners purchase the IMFL from the wholesale warehouses,
Which are duty paid.
which are already duty paid by the wholesale warehouses, and subsequently the same are being sold from their retail on shop at the MRP,
Yes.
which is fixed by the state government. And they are prohibited from collecting VAT separately from the consumers stock by issuance of circulars from the Finance Taxation Department, ID circular number 1411/2025. These IMFL retail on shop retailers have been asked to register themselves as dealers under the Assam Value Added Tax Act of 2003 and produce no objection certificates, which is used as a precondition for renewal of their licenses of the IMFL on shops stock. Learned, the petitioners are agreed that there is no requirement under the statute for payment of VAT by the petitioners at the point of sale from their retail outlets. And therefore, in terms of the provisions of the some VAT Act and rules itself, they are not required to be registered as they do not pay any, as they do not collect any VAT from the consumers stock. Learned counsel for the petitioner submits that the circular, where is the circular dated?
Yes, my lord. 14/11/25.
Where is that?
Page 94, na?
Page 94.
Page 94, my lord.
No, you referred to the
Page 75.
notification of 30th of September.
No, it's 3rd of July 25. my lord.
Page?
Page number 75. Those are the notices. Subsequently, in November 25, my lord, this circular was issued by the Commissioner, Finance Department.
Which circular?
Page 94.
94 circular. No, what about the 30th September 2015 circular? Notification by which amendments were brought in?
Section 10(1)(a), my lord. That loose copy I have given, my lord.
Yes.
Gazette copy. As per that, my lord, once we buy from bonded warehouse, then only there is a liability.
Learned senior counsel has urged.
My lord, in other words, they seek to draw this also part from 10(1)(a),
Right.
but it speaks of bonded warehouse, not warehouse.
Subjects that the circulars which are issued by the Finance Department calling upon the petitioners to pay, calling upon the petitioners to reply to the show causes which are issued as to why proceedings should not be initiated as they are found to be liable for payment of tax under the Assam Value Added Tax 2003. Appears to be on the wrong understanding of the provisions of the Act. Learned Senior Counsel has referred to the notification dated 30th September 2015 to show that Section 10 stood amended.
2016 amended the Act.
With the following, to stakeholders.
This was affected, but in
Referring to the same notification, the Learned Senior Counsel submits that
this become redundant.
the liability to pay tax on by the retailers would arise only when the IMFL is purchased from the bonded warehouse stock. However, with effect from the
One is there, but one the operation of 1B, 1C, 1D may rendered it inoperative.
When is the subsequent amendment where bonded warehouse?
Page 86, my lord.
With effect
The
from,
bonded warehouse, that is in the rules, my lord, 2016.
no, subsequently it has been amended to
85, my lord, page 85.
by notification dated 26th of August 2016.
26/8/16.
Amendments were brought in under section
10.
Section 10 to
After subsection A, the following new subsection 1B, 1C and 1D shall be inserted. Wherefrom it will be clearly evident, my lord.
3 new subsections were inserted, and a perusal of the same would reveal that purchase of IMFL liquor by the retailers are to be effected from the wholesale warehouses and not bonded warehouses. So the Learned Senior Council therefore submits that reading these notifications, it is clear that the imposition of by the state for payment of tax or registration under the VAT Act is totally uncalled for, as the same is not as the same cannot be conceived of in the scheme of the Excise Act and the rules, more particularly when, as on date, the retailers do not purchase IMFL liquor from the bonded warehouse, but purchase it from the wholesale warehouses. And it is the wholesale warehouses who sell the IMFL liquor, and the price includes the tax paid by the wholesale warehouses. Stop. It is therefore submitted that where the section 21 of the value-added tax prescribes registration of a dealer under the VAT Act only when the dealer is liable to pay tax. So, Mr. Chaudhary therefore submits that where the petitioners are not liable to pay tax under the VAT Act, the imposition of the excise authorities, the circulars and the show cause notices issued by the excise authorities calling upon the petitioners to show cause as to why proceedings should not be undertaken for short paid or not levied amounts under the VAT Act is totally contrary to the provisions of the Act, and therefore the same was issued without there being any power vested on the same authorities. He therefore submits that any authority of the state can only impose and collect taxes subject to the same being authorized by law. Under such circumstances, the writ petitions have been filed, putting a challenge to the show cause notices as well as the so-and-so circulars. Whereas Mr. Chaudhary, Learned State Council appearing to the Finance Department, submits that the writ petitioners have been issued separate show cause notices by separate authorities. All these have been clubbed together in the writ petition. Therefore, unless the reasons and the basis for issuance of the show cause notices by each of these authorities are clearly specified in the writ petition, it is not, the writ petition ought not to be entertained. Nevertheless, he submits that he would like to obtain his instructions in the matter. There are Mr. R.R. Gogoi, Learned State Council appearing for the Excise Department. What is your submission?
Lordship, that registration that came in 2015, they had to get them registered under the VAT Act, and that sale they made, on that sale, they had to put a 6% VAT to the tax department, Lordship. That's it. Registration is compulsory, and that 2015 rule has not been challenged in anywhere, Lordship.
Submits that under the VAT Act, the registration is compulsory. Interpretation sought to be given by the writ petitioner is incorrect. Furthermore, the 2015 circular has never been put to challenge. Under such circumstances, the apprehension expressed by the petitioners are unfounded, and the writ petition, the claims made in the writ petition ought not to be entertained in the present form. Having heard learned counsel for the parties, and considering the issues involved, this court is of the view that at this stage notice be issued. Accordingly, let a notice issue, returnable 4 weeks. The respondents, Mr. B. Chaudhary appears and represents respondents 1, 2, 3, 4, 5. And Mr. R. Gogoi represents
6 and 7.
6 and 7. If the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Meanwhile, till the next returnable date, the
Notices, my lord, from page 74 to 84 and the circular at 94.
notices issued to the writ petitioners. The
Annexure B
page-
series, my lord.
Notices issued to the writ petitioners is Annexure B series.
And this circular of
In
page
pursuance to
94.
the notices issued at Annexure B series, no coercive action be taken till the next date fixed. That will take care.
Further 94, page 94, sir. Okay, that will do.
That will take care.
Yes, yes.
We'll examine.
I'm deeply obliged.
Lordship, one thing I'm pointing out, Lordship, page 74, that notice has been issued by the Bongaigaon authority, but Bongaigaon authority has not been made a party.
But you raise at the time of filing your objections, but answer the main question.
Deeply obliged.
Because it will be difficult to answer that notice, Lordship.
You raise all these objections.
May,
What is this I?
Milord, IA is for only for a small correction, Milord. There was an inadvertent mistakes on our part, Milord. Milord, in the cost title, the name of the Milord petitioner number 10, the village was required to be Milord typed as a Gelazan, but we have wrongly typed as Hupguri, Milord. Milord, for this reason only, Milord, the petitioner is now suffering, though he is being protected, Milord, in subsequent litigations, but for this mistake, now the authorities are behind him, Milord. If my lord may be pleased to turn to the order of this honorable court, Milord, at page 11.
Page 14 is the order.
Page 11, my lord. A copy of the order at, my lord, kindly turn to page 12. This Ahmed Ali, petitioner number 10, my lord. Village has been typed, we have typed it, my lord, wrongly, Dhupguri. So, my lord, actually it was required to be typed as a Gelazan, my lord. That correction, my lord, we are praying, my lord.
No, how does it affect?
My lord, the effect is that because, my lord, in this Gelazan area, my lord, wherein the petitioner is now residing, in that area, my lord, had been protected by this honorable court, by the division bench as well as by the honorable apex court also, my lord. The status quo order is operating, my lord.
Yes, any objections?
For correction of the address, I have no objection, but there appears to be a second prayer.
No, that is mistakenly done.
I did not see how that is.
We are not pressing that prayer.
Paragraph, page number 9, your lordship.
Milord, this prayer B, we are not pressing, Milord. It has inadvertently been inserted, Milord. It is my mistake, Milord.
In the cause title, the correction has already been made, your lordship, prior to orders passed by this court. So otherwise, I have no objection.
Heard counsel for parties in the IA. The writ petitioner, this IA has been filed on behalf of petitioner number 10 in WPC number 4358 of 2025. So, in the said writ petition, in the cause title, name of the petitioner was reflected as so and so, page number 12, serial number 10. File over. Village is Dhupuri italics. Stop. On the said writ petition, a coordinate bench had passed an order dated 29/7/2025. Whereby, while issuing notice, the following order was passed, para 9 and 10. Para learned counsel for the petitioner submits that subsequently that they have noticed that there is some corrections in the particulars of the said petitioner number 10, namely so and so. And instead of the village being reflected as Dhupuri, it should be reflected as Gelajan. And post office as Dhupuri.
Others is correct.
Post office Dhupuri and police station Urianghat in the district of Golaghat. So this error had crept in through inadvertence, and therefore the applicant seeks liberty of the court to make necessary corrections in the cause title. Mr. K. P. Pathak, learned counsel representing the Forest Department, does not object to the prayer made. Accordingly, his IA stands allowed. The post title be corrected with the name of the petitioner number 10 in WPC number so and so be reflected as page number 2. Whereas this order shall be read together with the order dated 29/7/2025 passed in WPC so and so. Petitioner will file amended post title within 1 week from today. I accordingly stands allowed disposed of. In the writ petition you write, in view of the order passed today in so and so, name of so and so stands corrected as such and such. Petitioner will file amended post title, registry to make necessary corrections. Writ petition to be listed thereafter, and petitioner will ensure service of corrected copies of the writ petition and the respondents.
Obliged, highly obliged.
May I please, your lordships? In this case, lordships, petitioners were residing at Barsaitila D-Reserve area. Here is the case, lordships, by notification dated 17/9/1986. The Longai.
Why the IA has been filed?
IA filed, lordship. Now they have issued notice to remove our structures, lordship, residential house. That notice I've annexed a dependency of this petition, lordship. That notice is page 33, lordship.
Is it covered by that forest?
No.
No.
No. Though it is in the same district,
Yeah.
there is no survey going on.
Alright.
And this procedure which has been adopted in the notice as per the directions of the division bench. I have the order here for the division.
Division bench order.
That
In fact, a PIL had been filed. That PIL also same, relying on the order of the division bench, the PIL was also rejected. Similarly placed persons, not by them.
Our residence falls beyond the reserved area losses. The specific case is there. No boundary is there.
So if you're,
That is our case losses. And present notice in person Soboto PIL losses and as well as writ petition, writ appeal of in the respect of Gulagat district.
if your lordship has the notice at page number 33, at 34, the relevant reference to the appeal is there.
Sorry.
At page number 34 of the
Hmm.
type copy of the notice,
Hmm.
the reference to the proceedings before the division bench are there.
Hmm.
And the order I have just placed before your lordship.
No, have they submitted their documents?
They have submitted a representation, so that will have to be considered in terms of the directions passed by the division bench. We have to follow that procedure.
So you follow it.
Yes, your lordship, very well. We will.
Where is the division bench order?
It starts, the first order itself is a division bench order. The relevant portion is at paragraph number 21 at page number 18.
This whole bunch are pertaining to eviction.
Yes, your lordship. Similar, that order has been followed by coordinate benches and division benches.
In respect of Gulagat district, this writ appeal. And here is the Korumbang district losses.
Paragraph number 21.
There's a direction already issued here.
In this case, there is no direction
No,
lordship.
in the division bench.
Division bench lordship, our specific claim is that we are residing beyond the area. They have to survey.
Have you seen the order of the division bench?
I have seen, I have copy lordship.
You have
But-
copy. So division bench has given a set of guidelines.
Instead,
Let them follow these guidelines in your case.
Yes.
we submitted representation also. And even stating that our case is pending adjudication. Earlier
right.
occasions,
They will examine it.
Yes, your lordship.
this one court directing them to submit detailed affidavit against our case. No affidavit has been filed except one short affidavit filed by DFO lordship stating that as per report
What
of
do you
the
want?
lordship. At this stage, no coercive action shall be taken, lordship.
What coercive action?
So
Can there be a
otherwise, there
blanket
goes
order
to
like that?
eviction to me, lordship.
Can there be a blanket order, no coercive action forever?
Lordship, since my case is also pending, lordship, they have to be examined and verified. lordship.
That's right. That's what we'll do. We'll say that you examine this matter in terms of the division
Very
bench
good.
order.
Yes,
Till
Pass appropriate orders.
very well.
Do it within,
There is a period fixed, your lordship.
what is that?
15 days.
Huh?
15 days. And
15
thereafter,
days.
they have to be given 15 days for, and if they are found to be encroachers, then 15 days further.
No. From today, you give them 15 days.
They have already submitted a representation.
Whatever, but
Very
you
well.
still give them 15
Very well,
days.
very well.
Thereafter, you proceed, take into account whatever they have submitted and pass an appropriate order.
Very well, very well. In fact, if your lordship says that in terms of the time schedule followed, laid down, that will
even
perhaps,
one submission I have, even on lordship after survey found, we are inside the revenue. We may be allowed to give some land as per land policy 2019 also, lordship.
That
Our
will-
case is that we
that
are
will be a
beyond,
fresh cause of action, your lordship.
no, our specific, we are beyond the area.
That is a hypothetical
And that's the-
presumption now and it's a fresh cause of action.
Beyond the forest area or deeper into the forest area.
They have to survey it, lordship.
They have to survey.
Since there is no specific boundary is there.
Of course, there will be no boundary.
But our specific case, we are residing since so many decades, lordships, prior to 1914 also, our forefathers, then we are residing. And beyond that area, our.
Now,
specific-
here there is no survey taken up.
No, here there is no requirement.
How will you find out?
We'll undertake that exercise, your lordship will, no cadastral survey is required here.
No.
In the,
The polygon,
yes, here that is, we'll undertake a survey using GPS coordinates. We'll see if they fall within the forest area. We'll visit the site. But the other issue in the other matter, a cadastral survey regarding, using polygons, that was required. Here, perhaps that will not be required. If required, we'll do it.
how can you do it? It has to be by the revenue department.
If required, because the period of 15 days is given. So we'll come to a conclusion within the period of 15 days as to whether they are inside or outside the forest.
Well, I heard counsel for parties. The petitioners before this court claim to be residents of Badshatila of Longai Forest of Lower Pua Range in Karimganj subdivision. At the relevant point in time, they subsequently, by notification number 1598R, dated 14/6/1926, portions of land falling under the Badshatila have been de-reserved for occupation of the road petitioners and others. Petitioners submit that they have been residing and possessing their land on the western part of Badshatila and the Moza Icharpar revenue village since their forefathers. Notwithstanding their claims over this land, the petitioners were served with a notice on 1/7/21.
No, it is 2026 lordship,
Huh?
Page number 33.
page 33.
Of,
2nd of January 2026.
of what?
2026.
No, the writ petition.
IA lordship.
India.
No, why did you file the writ petition?
Without any notice, they damage the houses of the petitioner numbers lordship. Some of the petitioners, five of the petitioners houses damaged lordship. And as such lordship, we approached apprehension of eviction lordship.
They served with a notice on 1/7/2021. And no, they were not to cut it also.
On
That on 1/7/2021,
without any notice, damage.
without any notice, the forest officials along with police personnel came to the villages and started evicting and demolishing the houses of some of the petitioners. Being agreed, present writ petition has been filed. Notices in the matter were issued as far back as
Issued 8/6/2022 notice.
8/6/2022. 8/6/2023. And however, no interim orders were passed during the pendency of the said writ petition. Another notice. Page number?
Page number 33. IA.
Notice was issued by the Divisional Forest Officer, Karimganj Forest Division, Srivali, seeking eviction of the writ petitioners from their said land. Petitioners have therefore filed an IA, being IA number so and so, seeking adequate interim orders protecting their rights and interests. Para. Mr. K.P. Pathak, Learned Counsel for the Forest Department, on the other end, has placed before the court judgment passed by division bench of this court, rendered in Writ Appeal 251 of 2025. This writ appeal arose from an order passed by coordinate bench in respect of the similar matter, where the petitioners therein were sought to be evicted. So the division bench considered the matter and laid down the following guidelines, para 20 onwards, extract. Yeah. Has placed before the court the said order passed by the division bench. So then counsel for the parties have been heard, pleading available on record have been used. order of the division bench also has been carefully perused. Upon careful perusal, it is seen division bench by the order dated so and so has while deciding the issue, similar issue which arose from order passed by coordinate bench, laid down the following guidelines, para 20 onwards, extract. Para. In view of the finding by the division bench and the guidelines laid down by the division bench in the said order, this court is of the view that the same guidelines are equally applicable in the facts and circumstances of the present proceedings. Accordingly, the writ petition stands disposed of with a direction to the respondent authorities to strictly adhere to the guidelines and the timelines, guidelines and the timelines laid down by the division bench in the judgment and order dated so and so, passed in writ appeal number so and so. The writ petition accordingly stands disposed of in terms of the above. IA so stands dismissed.
Deeply obliged.
One submission lordship since
Huh? Another matter.
next one similar, same area lordship, but one submission lordship since they have excluded some portion of the land that may be added lordship. While
That is a
verifying the
factual issue,
claims,
your lordship, perhaps that
while
may-
verifying the claims lordship, our specific prayer in the deed petition lordship, we are excluded area. That may be verified lordship.
You examine, they will
That
examine.
will be
everything.
examined, your lordship.
They will examine everything.
Deeply obliged.
Yes. Item 26 also displayed of, along with a 9. We are keeping that bunch of orders.
Item 27 and 28.
My lord, in
Right,
this case,
so they will agree to those order. এটা কপি বনাই পেলাই ডিভিজন বেঞ্চটো দি দিব, এইখিনি ৰাখি থোৱা দিব। তেনেকৈ লিখিব পাৰি।
my lord,
Yes.
sir, may kindly be passed over to my senior lord lordship. He was here.
Not passed over today.
No, for the day lordship. Not
the
for the
day.
day, no, not lordship,
For
for
the
the
day.
time being. For the time he is coming lordship, after some time.
You can open up. What is it?
Lordship, but he, regarding he also prepared lordship, sir, are good.
You are not prepared.
Instructed me, he will appear lordship after some time. Obliged.
Item 29.
Lordship, this IA has been filed for withdrawal, your lordship.
I number so and so. The IA has been filed by the petitioner seeking withdrawal of the accompanying writ petition being WPC 7518 of 2022. So the said writ petition was filed by the petitioner seeking a direction for quashing the eviction notice dated 10/11/2022 issued by respondent 5 against the petitioner organization. Stop, it is submitted that during the pendency of the writ petition, Government of Assam had sanctioned an amount of rupees 1,91,58,046 for construction of building, namely within quotes Moran Bhavan, quotes close at Guwahati, Dokhingaon Dispur. And subsequently another amount of rupees 4,4051,238 has also been sanctioned, completing the whole project. Under such circumstances, the writ petitioners do not wish to press the petition any further and seeks liberty to withdraw the same. Liberty for withdrawal of the same. And approach the court on a later date if the grievances still persists. Better. Anyone for the respondents?
And for 3, 4 and 5.
Any objections?
No,
Mr. J. Hendig appearing for
3, 4 and 5.
respondents 3, 4 and 5, MSPR on to for 1 and 2. Do not express any objections. In that view of the matter, the writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending IAs are also dismissed. Needless to say, if the petitioner's grievances subsist, they are at liberty to approach this court.
Pleasure.
27 might also be possible. 27, 28.
Yes.
I sorry, but I was just coming in the way my daughter. This case, my daughter, in the 27, we find an IA. Basically, your loss of kindness here, notice was given to the owner of the house, page 33, your loss of kindness.
Yes.
TE1. 1003E1. Under
Yes.
this. Your loss of kindness. So now, so far 3G, your loss of kindness, 3G2, kindly have a look at 3G2. 3G2, my lord, because the right of the user. That's on the. G surplus 2 mile, 3G.
Yes.
So lot kind of where the right of user or any right in the nature of the on the easement on any land is acquired under this act, there shall be paid an amount to the owner and any other person whose right of enjoyment in that land has been affected in any manner whatsoever by reason of such acquisition, an amount calculated at 10% of amount determined in the so one already that payment already made to the for the purpose of land mile. We are having construction my lord, that is the we shop.
No, no, land, whose land is this?
Land my lord, some persons here, most of the persons, we are the tenant. We have taken on rent the some shops my lord. We are in use for a long time my lord.
So the owner has been paid the.
Owner they pay the land.
Now you being the tenant.
Yes. Jirat, we are only for Jirat, my lord. Jirat part has not been assessed till today. They have neither filed an affidavit
So
nor
what is to be done?
My lord, that may be assessed only, my lord, Jirat, and then, my lord, because as per section 3GE, my lord, because 3E is a notice which was given, it says if you violate the order, then in that case, and my lord, possession may be.
No. If you are claiming under 3G2,
yes, my lord,
then the procedure prescribed under 3G3,
yes,
will have to be followed.
So that has not been, we have never been informed anything, my lord. Without deciding anything, my lord, they have issued a notice. When the eviction notice, this is also says, my lord, we have to be evicted also, my lord. And it clearly say, if we do not comply the order.
No. Does it say that unless it is paid that you can never be evicted?
No, it does not mean so, my lord, but it amounts to, my lord.
No. How
because we have a right, but once we have right, our right has not been determined till whether we are entitled or not. To decide as per 3, my lord.
Did you file any objection at the time when the notices for
we have been asked to file documents, we filed it. Again, we have been asked to file document, again and filed it, my lord. Nothing, no response till today, my lord. And now this notice has come.
Notice to the owner.
Notice to the owner of the land, my lord. It is directed that we hand over possession, your kind of page 34. Since the land has been acquired through the Gazette notification number so and so, then it is hereby directed that you hand over possession of your land, the number so and so, which falls within the designated alignment. Failure to voluntarily hand over possession of the land will result in action being initiated under section so and so. That then complete by the 3G3, my lord. You already informed something to us, my lord, whether we intended or not. And we are there, my lord, we have submitted 2 times our documents. The owners is permitted us to construct the houses, my lord. And we are staying there, we are doing our business also
but
there.
please see 3E.
Yes.
3E.
E. So power to take possession, my lord.
Yes.
That is their notice they have issued, my lord.
Hmm.
E is sub clause 1. The present notice which they have issued, my lord.
So that is mandated under the act.
Yes.
No, therefore, this, it comes to my, you know, kind of what it says, my lord.
Hmm.
Power to take possession, when? When it will come.
Hmm.
When it will be taken, my lord, everything is over. Then only power to.
No, read it.
Yes, where any land was vested in the central government under subsection 1 or subsection 3, and amount determined by the competent authority under section 3G with respect to such land has been deposited under subsection 1 of section 3H with the competent authority by the central government. The competent authority may by notice in writing direct the owner as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority or any person duly authorized by it in this behalf within 60 days of the service of the notice.
So the amount has been deposited, compensation.
So land,
Yes.
not owner, to the owner.
Correct.
So, but my day comes by the users.
That's right. So your claim will have to be determined, but does not mean that unless it is determined.
That is not there, my lord, especially, but your lordship makes, so it's because unless,
how can we-
but unless 3 is applied, my lord.
No,
Three
but
is-
this is the mandate of the statute.
So let them do, my lord, that it within, otherwise 60 days is also there, my lord.
No, that they will do.
Ah.
What we want to say is 3E and 3G2 or 3 are independent.
Independent, but my, it follows your lordship, can be all are 3, it all come under 3, my lord.
It all comes, but the power to take
E,
petition.
F, G, all are,
only
yes, it
with
is,
regard
but
to
it follows from 1 to that right, my lord.
Yeah.
Not in independent right, my lord, otherwise, my lord. It follows
So
from.
your claim essentially is against the landowner.
Not my lord, in fact, not landowner.
Why?
Because
Your tenants.
my right comes from 2, user. I am using the land, my lord. I am not claiming that I am the owner. I am using the land, I am the user. I have no complaint against the owners, my lord. I am not saying that owner is not paying, my lord. I am not saying so, my
No, but we'll issue notice here in the I. Mr.
lord. I
Richard.
only, my lord, as per, before that we may not be, my lord.
Lordship, in
because
this case,
lordship-
Lordship, I have received the instruction, Lordship. 3D notification was published on 12 March 2024, Lordship.
Yes.
And Lordship, they have started the construction in the month of December 2024, Lordship. I have the photograph also, Lordship.
They have started.
Yes, Lordship, already
Oh,
constructed
my
also,
God,
Lordship.
they
I have the
have
photograph,
already
Lordship, after
reply we have
publication of the
been given.
notification, Lordship.
We have been asked.
So
to
now they
submit-
are want compensation, and some of the petition also received the compensation also. I have the instruction also, Lordship.
No, none of the petitioners.
Petitioner number 20, Lordship, his brother received 22 lakh,
Bring
21
it on
lakhs.
record.
Yes,
Bring it on
Lordship.
record, right? Mr. Richard Chaudhary, Learned Senior Counsel, assisted by Mr. F.P. Bobby. For the applicant, Mr. appears for the National Highway Authority. You represent the union also,
Lordship, I
the respondent number 1
So,
and
5, Lordship.
national number 5, respondent 5. Mr. J. Hendick appears for
For respondent number 3, 4,
respondent 3, 4,
3, 4 only.
3, 4. MSPR Monto for respondent 2. And rules for 6 and 7.
PW man.
Any PWD council? Mr. M. Bhuya.
No, Lordship, somebody else slotted, but it's okay, Lordship. I can.
Who is appearing here?
Lordship, in this case, I believe M. Das was here. She was just here.
Chief Informer, MS
Lordship.
M. Das appears for respondent number 6 and 7. The petitioners claim to be tenants. And what are you doing there? You're running shops.
Shops, my lord.
Running their shops on
Since prior to the acquisition notice, man.
a plot of land.
7%, 8%. 18. Huh? 24 petitions.
What is the land area? covered
Yes,
by?
we have stated, my lord, in paragraph details we have taken, stated in paragraph, paragraph 3, my lord. Three, paragraph 3. In 4. Yes, 4, my lord.
It's 14.
No.
It's
Yes.
Not IA. IA page 3. In IA page 3.
In IA page 3, paragraph 3, sorry. Okay.
Page number 18 to Sailuba. Applicant 1, 2, 3, 4 लिखा है, they're running their businesses covered by land dark number so and so, so and so, so and so.
Paragraph 3, whole paragraph 3.
The advance of the petitioner is that during the process of acquisition, the portion of land on which the shops were established has also been acquired, and the shops have been damaged. However, the compensation payable to the petitioners as users of the land has not been granted. Stop. Learned Senior Counsel, referring to section 3G within bracket 2 of the National Highway Act 1956, submits that under the provisions of the said act, there is an entitlement of adequate compensation to be paid to such persons whose right of enjoyment of the land has been affected in any manner. So the petitioners are affected by the process of acquisition. Regarding their enjoyment of right of enjoyment of that land, and therefore the respondent, therefore these by the instant IA, they have prayed for direction to the respondents to consider their claims for payment of adequate compensation. Mr. Talukdar, on the other hand, representing the National Highway, submits that the construction has already been undertaken.
Yes, sir.
With effect from
Lordship. With effect from Lordship 13/12/2024.
13/12/2025.
24.
24.
Notification.
After publication of the notification.
After publication of the notification. He, however, submits that he would like to complete his instructions on the averments made in the IA. Learned State Council representing the other departments are also permitted to obtain the required instructions in the matter. But having heard learned counsel for parties and upon perusal of the averments made in the IA, as also the provisions of the National Highway Act 1956, it is seen that the power to take possession is on the National Highway Authority is vested under section 3 capital E. Stop. However, the persons whose right of enjoyment on a land which is acquired gets affected in any manner is also required to be compensated as per prescription of section 3 capital G within bracket 2. Stop. The procedure prescribed is laid down under section 3 capital G within bracket 3. Stop. Under such circumstances, while permitting the respondent authorities to complete their instructions, let notice issue, returnable 2 weeks. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Tendency of these IU shall not be a bar to process the claims of the applicants as per the provision of the Act. Matter being listed after the returnable book. Let them have their instructions.
This is for admission item 4.
May it please your lordship.
Yes.
The victim has not received as per the interim order, lordship. He has not yet received the amount.
What?
Interim of 1 lakh compensation. Additional compensation, lordship.
Who's for the respondents?
Last occasion, sir,
Huh?
CDSC, the Ranjit Dev Sudhuri was asked to submit some instruction. You might be leg in the code number 1.
As annexure 3, lordship.
Who is for any other CGC?
Mr. Dev Sudhuri is there.
All right, list on, let it come up next week,
He
Yes,
might be in
lordship,
the
27th.
not 27th. Let it be on 30.
May it be on 28th because 30 I'll be out of station.
28, we have a lot of other matters. Then you take it on 2nd of February. List on 2nd of February. Enabling the learner CGC to complete the instructions as to why the directions for payment of compensation to the writ petitioner has not been carried out as on date. MSD Ghosh for the writ petitioner.
Item 5.
May
Yes.
it please the lordship. Lordship, in this case, lordship, we have challenged the bunching of SOCO's notice. Why the SOCO's notice, which has been issued to us, by demand come SOCO's notice, dated 5/6/2025. Lordship, this case stay has been, lordship, we moved the case and lordship, a stay order was given to us on 17/11/2025. Lordship, this case, lordship, the issue raised in this case is lordship sub judice before various high courts across the country. Lordship, 6 high courts have already given a favorable judgment. And
Where is
lordship,
the
one high
judgment?
court, the 7 high courts have given the lordship favorable judgment. 1 high court, lordship, Delhi High Court has not given a favorable judgment. Lordship, may kindly see the interim order which has been passed on 17/11/2025. It has been passed after considering the entire issue.
Interim order on
17/11/2025.
17/11.
Lordship, it was moved very recently, Lordship. 17/11/2025.
Consolidated for
Yes, your Lordship.
reality.
And Lordship, the different high courts have said that.
Here, this honorable court has called similar on this issue.
Where it was,
My learned friend was appearing in that case also.
what do you say about that?
Paragraph 11, Lordship. In that case, Lordship, final order was passed.
Where it has been upheld on both counts?
Yes, 11, yes, Lordship. Paragraph 11.
Yes. This is covered by coordinate bench judgment.
Lordship, I don't know about the name of the judgment because Lordship, this I have challenged the bunching of notice.
The order.
Lordship,
Your name is recorded in the order.
Lordship, which case, Lordship, if your Lordship may kindly, I have no.
WPC 4694. Rasidul Haq.
Lordship, that is a different case altogether. That is a case wherein we had not challenged the consolidated notice. That is a case where we had said that we had come against the order in original. The court said that alternate remedy is there, you go to the alternate remedy. And the court has given us time that, okay, you pay 10% and then you whatever. Because that was against the seizure of my account. Seizure of my account, not against the consolidated notice, Lordship.
Where is the illegality? Where, under
Lordship,
what
the
specific?
illegality. Lordship, the
Under
illegality,
what?
Lordship, Lordship, the
What
illegality is
specific?
that if they give me a consolidated notice. Lordship,
Under what provision is it prohibited under the GST Act?
yes, your Lordship. This is what Lordship I would like to place. Lordship, because Lordship, this specific issue has been dealt in by the Bombay High Court. Lordship, and as well as the Kerala High Court and the Lordship Karnataka High Court. Lordship, I have Lordship argued the entire case in length, and thereafter only Lordship this Honorable Court has passed the interim order. They have filed the affidavit also, Lordship. I wanted some time to file my reply because Lordship they had Lordship relied on judgment of
Why do
Ambika
you
Traders.
file a reply?
Lordship.
Yeah, it is already decided by several high courts, so why you want to file a reply? The question is on a legal issue.
Because Lordship, because they have relied on judgments of the Lordship various High Court also. They have also relied on. Lordship, I have to give some reply because those are not. So Lordship,
27th of January, we'll hear you.
Lordship, if it can be fixed on Lordship in the month of February, Lordship, I'll file a reply, Lordship, short reply, Lordship.
Council to be present on 27th, we'll reconsider your prayer on
Yes,
27th.
Lordship.
Yes.
Lordship.
MSN Havelia and Mr. Ezekiel for the GST matter be listed again on 27th of January. You have
Lordship,
already
interim.
completed.
We have already filed our affidavit.
Yes.
Interim may continue, Lordship, till that day.
Three orders passed earlier will. Yes.
Lordship, Lordship may pass order directing them to deposit in case. In case.
Why?
Because Lordship in under 130, there is no provision for bank guarantee. If my landlord agrees, then
How can they deposit in cash?
Bank guarantee is equivalent to the cash and it's easier.
Lordship, Section 130 doesn't provide. This is my instruction.
It is equivalent to.
Section 62 provides for if the goods are seizure, then it can be released on furnishing bank guarantee loans.
If ultimately it is upheld, my lord, they can release the bank guarantee.
Lordship, probably there may be any no difficulty.
No, where under section?
130.
130.
Lordship. So notice under section 130 was issued.
129, 130 was. 130 penalty go ahead.
Okay. Classification of goods for conveyance and levy of penalty. They may deposit under protest, Lordship, that will be after final litigation, Lordship, for.
Such a mighty union is there, if you have to only buy with my amount, the cash amount, if they can necessary for them. As you know, citizen.
I heard Dr. A.K. Saraf assisted by Mr. A. Poshek and Mr. P.K. Bora. Learned counsels appearing for the petitioner and Mr. Ezekiel along with Mr. K. Jain appearing for the GST authorities. Petitioner before this court is you're a trader
Hello.
of Supari. He's a trader in the business of sale and purchase of various commodities, including betel nut, dried erica nut. during the process of course of business, the goods which were transmitted in vehicles by the petitioner were detained by the GST authorities purportedly in exercise of powers under section 129(1) of the CGST Act. Stop. The goods were detained on the ground that they were undervalued and the vehicles along with the Erika Nath consignment were seized by the GST authorities. Detention orders. What are the detention orders?
Well, detention order is only one. Detention order, yes.
Detention orders dated so and so was passed.
Legal cases need to,
Learned senior counsel for the petitioner submits that this entire action by the respondent authorities is in contravention with the powers described under the GST Act under section 129, 130. So the learned counsel, senior counsel submits that the respondent authorities by issuance of
Next to it.
this page 160 is the
We're at page 129, the detention order.
59.
129.
129.
129 and 130, 31.
Detention orders were passed on the ground that discrepancies in weight after physical verification was noticed. And an amount of rupees, and goods weighing 1310 kilograms were found to be not covered with invoice and EWB. So thereafter, the respondent authorities issued notice under section 130 for confiscation of the goods and the levy of penalty. So penalty was calculated along with fine in lieu of confiscation of goods and fine in lieu of confiscation of conveyance amounting to a total of 79,55,156. Another senior counsel, referring to the provisions of the GST Act, submits that the confiscation under section 129, detention seizure under section 129 in respect of goods and conveyances in transit is only when there is when the goods are in transit in contravention to the provisions of the Act. Such instances are not seen in the present proceedings, inasmuch as the goods were duly covered with necessary documents and invoices. And according to the respondent authorities, there is a discrepancy in the weighing of the materials, which the learned senior counsel submits could have resulted as the goods were weighed without the
With Milord, weight with bags
that is by you,
by the person, Milord,
by the petitioner.
by the respondent.
Respondents were weighing it without the bags.
They weighed it with the bags.
With the bags. As the consignment, namely the Erica nut consignment was weighed with the bags or the materials in which the consignment is packed and sent in transit stock. Learned senior counsel therefore submits that besides there being a dispute in the weighment of the weighment of the goods which have been confiscated, the authorities have not been able to point out any instance where the goods were sought to be transferred or transmitted without following any procedure as contemplated under the Act and the rules. So, Dr. Saraf has referred to a judgment of coordinate bench of this court reported in 2005 3 GLR 425, so and so, to submit that at the checkpost, the officer is not entitled or empowered to referring to the same judgment, the learned senior counsel submits that in cases of registered dealer, which the petitioner is also falls within the same category, if the total quantity of goods in stock or in transit are identifiable and the variety thereof is also known, to hold the goods not properly accounted for merely because there is a difference of opinion as to the sale price thereof, in the considered view of the court, would be doing violence to the scheme contemplated under the Act. Dr. Saraf has also referred to the judgment of the Gujarat High Court rendered in so-and-so versus so-and-so, to submit that in order to invoke the severe action of confiscation of goods and conveyances during transit, contravention or infringement has to be one of the highest degree, such as absence of documents or fake or forged documents, absence of details of the dealer, forged e-way bills, complete deceptive / divergence / mismatch of goods, fake registration, etc. He therefore submits that insofar as the goods of the petitioners are concerned, no such instances have been recorded by the respondent authorities, and therefore, at this stage, the impugned seizure, detention, and confiscation, contemplated confiscation of these goods are contrary to not only to the provisions of the Act, but also to the judgments and orders passed by this court as well as by the High Court of Gujarat. So he therefore submits that these proceedings be stayed and the petitioner be permitted to, as the consignment seized is of perishable nature, petitioner's consignment be released and necessary documents, etc., sought for by the petitioner be furnished to the writ petitioner so that appropriate reply can be filed in response to the show cause notices issued. Dr. Saraf therefore submits that during the pendency of the matters, the adequate interim protection be granted by directing the respondents to release the confiscated consignment of Erica nut seized by the respondent authorities. Mr. KL, on the other end, submits that there is no infirmity. The procedure prescribed under section 129, 130, read with 131 has been followed. The show cause notice has been issued. The respondents have not replied to, rather has sought for further time. Having heard the counsel for the parties and upon perusal of the pleadings available on record, and upon due perusal of the relevant sections, i.e. section 129 and 130, 131 of the GST Act 2017, as also the judgments pressed into service by the counsel for the petitioner. This court is of the view that the matter will require consideration. Therefore, at this stage, notice be issued. Accordingly, let notice issue. Return in 4 weeks. Mr. SCKL appears and represents all the respondents. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Meanwhile,
Prayer is at page 86.
considering the submissions made, page
86B, my lord.
86.
My lord.
Considering the submissions made by the petitioner and more particularly the judgments pressed into service, wherein it has been clearly held that difference of opinion in respect of weighment or weight of the consignment ought not to be the sole ground for seizure and attempted contemplated confiscation of the goods in question, more particularly when these goods are perishable in nature. Stop. It is also noticed that there is no allegation against the writ petitioner that they had submitted that these goods in transit were not supported by adequate documents, end of rigor, they were fake forged documents, or there was absence of the details of the dealers or forged e-way bills, or are completely deceptive, divergent, or complete mismatch of the goods, end of rigor, fake registrations, this court is of the view that subject to payment of subject to securing the amount by way of a bank guarantee. What is that amount?
Of the tax amount, my lord. 3,61,598.
Page number?
Page number, my lord, 161.
61.
3,61,598. You'll also find bottom 180 so-and-so as GST and 180 CGST.
the tax subject to furnishing of adequate bank guarantee to cover the demand of tax short paid, namely rupees 180,799
For CGST,
respectively for CGST and for SGST.
similar amount, my lord.
A similar amount,
Lord.
amounting to a total of
3 lakh
3 lakh
61,598.
61
598.
598. Stop. If the petitioner in pursuance, in deference to this order, furnishes the adequate bank guarantee before which authority?
What's it for respondent number?
Commissioner, maybe principal commissioner, no, that will be better.
Principal Commissioner, Lord. Respondent number 2.
Respondent number 2. The goods along with the vehicles
Well,
shall be released
so you'll also be,
forthwith.
we mention below vehicle number also, my lord.
The
Vehicle number.
particulars,
86B.
the particulars of the vehicle numbers are reflected in prayer B of the writ petition, which is extracted below.
Lordship mentioned, my lord, that they will supply the requisite papers so that.
Lordship, regarding that, Lordship, I have obtained
The-
inspection.
Better.
Lordship,
The-
here I have a submission.
It is also submitted during the course of the hearing that pursuant to the cause notice issued, the petitioner sought for detailed and necessary documents, which as on date are stated to have not been supplied.
2 documents has been supplied. Regarding Lordship, I have instruction that some other proceeding is going on that is related to that they have not sought for.
You give whatever orders you want to give on this application which is pending.
No, Lordship, we have already replied to them, Lord.
You have.
Yes, Lord.
After that, we have given, my lord, that these are the
They
documents.
have given a chart.
We have given a chart, my lord, that these are documents which have been referred to in so-called notice.
So have any reply been given?
No, no.
No, Lordship, one reply has been given.
Earlier it was given, my lord. Thereafter this.
Not after the
No.
one with the chart. Give a reply if you want.
I have obtained instruction. They said that some other proceeding.
Let the authorities give a reply to the.
I'll give, Lordship, we give reply.
What is the harm in giving
And Lordship,
documents? my lord?
another thing, Lordship, regarding
And
130.
assuming it is required for some other proceeding, all they want is extract of the copies.
Give us copy or will you give a reply?
That's all.
Lordship, I'll submit my. Lordship.
All necessary documents as prayed for by the petitioner. And as intimated to the department by communication dated 31 December 2018.
On receipt of.
Will
the
be
document
examined and furnished to the petitioner, and upon receipt of the same,
within 2 weeks.
the petitioner will file necessary reply within.
Regarding Lordship, bank guarantee, my submission may kindly be recorded.
2 weeks
So
thereafter,
under section
yes.
130, it is not provided. They have to deposit in cash.
How will they deposit it in cash?
Lordship, because under section 130, there is no provision for submitting bank.
It is equivalent to cash, Mr.
Lordship, correct, Lordship.
Ah.
Lordship is correct. Lordship, my objection may be recorded.
Well, in second case, only number etc. will be different if you lost the permit. You know, they will.
Yes, they will submit.
Lordship, in second case, the quantity is 22,120. There is a discrepancy.
I show, my lord. You also see the delivery note. Which is available. They have not taken into account at all. Delivery note.
When was the seizure made?
It was on 22nd December. So detention, Lordship, it was on 25/11.
Of
25.
25.
Lord.
Now then why, I think, in the earlier matter, if you come to page number 219, in the earlier writ petition,
Lordship.
there could be some, the date perhaps is wrongly written, is it? Is 2018 is shown? Or it should
No,
be
no.
25.
The vehicle was intercepted on 1/11/2025.
No. The communication where you have reflected the documents which you want and why in terms of the chart.
Why submit, Milord? Milord, they have taken for valuation purpose, the documents of some other seizure.
No, we are not on that.
My lord.
This communication is dated 31st of December 2018.
Oh, my lord, this is,
This should be 25.
no, this is Government of India circular, Milord. Page 219.
Oh, sorry. So which communication are you referring to?
Well, I communication, I was with the, yes, Milord. Yeah, I'm going to reply the other. This is Milord at page 180,
180.
my lord.
Sorry. This was sent on 9/1/26.
My lord.
Okay. Last date say asil 31st December 9/1/26.
Then 16/1/26, again we have given by page 183.
Followed by 16/1/26.
My lord. In the second case, Milord, I
Yes,
will not trouble your lordship.
yes.
With your lordship permission, Milord, the dates and subject will be changed.
No, you were pointing out something. of
Yes,
the
lordship, here-
quantity.
Here,
I've shown the quantity is saying,
page 125. Lord.
you lost me see.
Page 125.
125.
Not so. There is a,
There's no difference. Page 90, you also see. You are not taking into consideration, it's most arbitrary way they are doing.
lordship, here.
No, he is only pointing out the
Yes,
quantity.
yes,
of
lordship.
difference.
Quantity, page
Ye-
90, you also see.
90,
lordship.
90, 90.
90.
Maybe not 21,000 kg.
What difference does it make? It's on the same
It
principle.
is 22,215, lordship.
So 1,000 something is the gross
Is
weight.
is it a case that these are not covered by any documents or
Lordship, I'm referring to the notice.
only the quantity?
Quantity, lordship.
Let him refer below the quantity also to the SS officer, whether it is there or not, because.
Yes, lordship. Because they have to file their reply and lordship, they have to execute it.
They are not going to finish it. After all, we must file a reply, adjudication, and all.
You ask your junior colleague
Well,
to
the date is with your permission.
Lordship, again, I'm repeating, lordship.
bank guarantee.
Yes, we can.
All right. Mr. S.C. Kyal, Leonard, Standing Council, GST submits that under section 130.
130. 130.
130, there is no provision to receive
Bank guarantee.
bank
Furnish-
guarantee. So, therefore, the petitioner be directed to pay the amount in cash stock. Such contention of the petitioner of the respondent at this stage cannot be accepted as the court has passed an interim order upon prima facie satisfaction and therefore directing the petitioners to pay the amount in cash into the exchequer will amount to accepting that the petitioner is liable to pay the tax. Nevertheless, the interests of the revenue are well secured with the order of this court that the amount of taxes liable to be paid by the petitioner shall be secured, duly secured by bank guarantee, which will be renewed from time to time.
Certainly.
Much of.
Second matter to detail के लिए ले लेगा. Yes.
So after he's 3 minutes, after the meeting.
You can give it to the court master. Take it. Court master, you take the particulars of the second matter. Yes.
Lord, these are the matters, my lord, relates to that eviction process which been initiated, my lord, from the tribal belt. Mainly, my lord. Lord, I am holding the WPC 335 of 2026, my lord.
Yes.
My lord may be pleased to find the notice which has been issued, my lord, is at page 178, my lord.
178.
My lord.
Yes.
My lord, this is a notice issued under section 165(1) of the 1886 regulation, my lord. My lord has already gone through this notice yesterday also, my lord, as an order had also been passed to the similar area. My lord, only thing is that, my lord, we are, my lord, residing in a different area which has not yet been earmarked or comes under the purview of a tribal belt, my
Do
lord.
you have a copy of that order yesterday?
Yes, my lord, yes, my lord.
Show us what order we passed.
My lord, it had been fixed on 28/1/2026, my lord. And the reply which we have filed, my lord, before the authority along with our documents, that no action has yet been taken on our reply, my lord. So my lordship, ask my learned senior friends, my lord, to obtain the instructions that what is the stage of the reply, my lord, which we have filed.
Is this case also similar?
Similar, my lord, similar area, similar, my lord.
So let it come up on 28.
28, my lord. My lord,
We
only
are
thing
passing
is
the
that,
same order.
my lord. My lord, only instruction in these cases we have received, my lord, immediately after this 26th of January, they are preparing, my lord. That's apprehension. We are passing sleepless nights, my lord. That anytime something may happen, my lord. That's the problem, my lord.
Now the problem is that you all claim to be in possession of the land for years together.
Years together and.
Now you know the procedure.
My lord.
That when you are in possession of a land, you have
My
to
lord.
make necessary applications before if it is a government land, it's a vacant land, waste
Patta land, my
land.
lord. We are residing in our own patta land, my lord.
That's right.
My
So
lord.
therefore, if it is a patta land, then without your pattas being
Cancel, my lord.
cancelled, how can
They cannot
it be
evict
done?
us, my lord.
So somebody will have to undertake this exercise, whether these lands are in actually patta land.
Yes, ma'am. We have
or
annexed.
they are staying in patta land, but also occupying
Tribal belt, my lord.
tribal or
Elise,
government
they
land.
have Elise, my lord.
And in the guise of having the patta,
My lord.
all these will have to be examined.
Examine, my lord. Examine.
And that, my lord, no, that 1 month period, my lord, that window period has not yet expired.
That is correct.
Which is that wonder 28 one?
29.
29.
12.
2912.
My lord.
29/12.
So 2912 don't do anything.
Because last week
It will be listed on 28. Let us see
My lord.
what happens. You serve extra copies.
Yes,
today.
my lord.
by today.
Today, I will,
Already same already.
my lord.
I'll list it along with this matter.
Sob din daga.
Yes,
My lord. My lord, next item is also similar, my lord.
similar.
My lord.
Okay. Similar.
My-
It is right.
Obliged, my lord. Highly obliged.
So, like,
Oh, Mr. I'm sorry, we did not record the name, Mr. A.R.
My
for
lord.
the petitioner, Mr. N. Goswami for the state, and Mr. R. Borpujari for revenue department. Both the matters.
Deeply obliged.
এইফালে ফেনখন চলাই দিওঁ তই।
Please, madam. As per the last order, they were supposed to file their affidavit. As per the last order of 9/12,
Yes.
the state was supposed to file their affidavit.
Lordship, we will be filing it positively. Lordship, will give us 2 weeks time. We'll be filing it positively.
2 weeks time.
Lordship, it's a voluminous affidavit. We'll be filing it positive.
Okay. Mr.
K. Talukdar.
K. Talukdar. For the council association of petitioner, Mr. M. Bhuya.
Lordship.
Yes, for the respondent, Mr. Bhuya renews his prayer for further time to file the affidavit.
Lordship.
He prays for 3 weeks time.
Lordship.
List again after 3 weeks.
The interim to continue.
Interim orders passed earlier, if any, will continue.
There's only one thing, if they positively file it by the next day, because there's some urgency on
We'll
that.
positively file it.
We are protected by interim order.
But whereas there is a recovery done at the time of the search. 6.5 crores have been
Then,
recovered at the time.
2 weeks for you.
Lordship.
Matter be listed on 18th,
Lordship.
18 February.
Lordship.
I'm grateful.
Much obliged, Lordship.
No, the issue revolves around classification of land. This petitioner, my lord, he was having a land of 2 bigha, 1 kata 6 lesa. This is in a Panikhaiti area near the main road. My lord, in the year 2018, my lord, 16 in fact, he had applied for reclassification it from agriculture to commercial. My lord, all due approvals, my lord, were given, and this is to be done under the Assam Agricultural and Land Regulation Reclassification Act of 2015. And in fact, my premium of 3 lakh rupees 21,000 was also, my lord, duly deposited on 3/12/2021. Thereafter, under section 5(7), the deputy commissioner has to issue a final NOC for, my lord, making the necessary entries in the revenue records as far as correction of classification of land is concerned. At that juncture, my lord, the matter came to a standstill after my deposit and every all formalities being completed. And the issue transpired that that particular land, my lord, falls within an eco-sensitive zone of the Amsing forest area. There's no dispute about that, my lord. The limited issue, therefore, that remains, my lord, that under the classification zone, my lord, that is there for the eco-sensitive areas, certain activities are prohibited. Other than carrying out those prohibited activities, my lord, our case is that there is no bar as such for making it a commercial land, subject to the fact that I comply with the fact that I do not undertake any of these prohibited activities, which is barred in a eco-sensitive zone, my lord. Those notifications, my lord, have also come on affidavit, my lord.
What activities?
Lord, you would see running page 60, my lord. It's an additional affidavit, my lord, filed by us. The same thing is again filed by the government later on.
Prohibited activities.
Prohibited activities are there. Commercial mining, setting up of industries, thermal and hydroelectricity project, processing hazardous substances, setting up of sawmills, basically, my lord, industrial activities.
What activity you want to carry out?
My lord, initially I wanted to, my lord, put up a petrol pump there. But then since part of the frontage of the land, that also has come on affidavit, that since part of the frontage of the land has now gone for the expansion of that particular highway in the 6-lane project, I cannot do the petrol pump, so that project is already abandoned. Now, after reclassification, my lord, any of the permissible activities I might carry out, my lord. That, of course, I have to take a separate permission, but then that does not per se bar reclassification.
No, but you'll have to indicate what activity you want to carry out. It can't be classification first,
my lord,
and then you disclose what activity you want to carry out. It has to go.
Commercial conversion is, my lord, granted on the fact that whether what is the neighboring land, whether it is still used for agriculture, and whether, my lord, neighboring lands are agricultural or, my lord, non-agricultural. My neighboring lands are, my lord, there are industries. There is a report from the forest, my lord, to that extent. There is the downtown university, there is the Pratiksha nursing home. So all commercial activities are there, my lord. So therefore, this land is no longer agricultural. After conversion as to what, my lord, activities I would carry out would be, of course, governed by this particular notification that I cannot carry out any of these activities which are prohibited. For that, my lord, there are provisions also, my lord, under the particular notification, my lord, there is a committee. That committee will monitor whether I have set up anything which is prohibited, my lord, as per the eco-sensitive zone notification. If that activity is carried out, they will take a separate action, my lord, and that would be a separate cause of action. To that extent, my lord, some of the previous orders had also recorded, my lord, my submissions. And government was to, my lord, clarify, understand, and the affidavit file only says, my lord, that this is the notification that is there, which we agree that yes, I will not carry out, I cannot, in the petrol pump project, everything is already abandoned. So, other than that, my lord, I can put up a restaurant also there, my lord. I can do organic farming, I can do skill development, I can do eco-friendly transport.
Organic farming is again agriculture.
There are prohibited activities and there are some activities which are regulated. and some prohibited. Industries are definitely prohibited, my lord. Everything else is regulated or promoted, my lord. Ecotourism is there.
Yeah, Mr. Goswami.
Lordship, in our affidavit, Lordship, one affidavit filed by Assistant Commissioner, Lordship. Assistant Commissioner respondent, Lordship, respondent number 2, therefore, in the affidavit, Lordship, in para 7.
57, no? 54. 54.
54, no?
54.
No, he says other than the prohibited activities,
Other,
he wants to, he may pursue some other activity,
Lordship,
provided the land is reclassified.
Lordship,
So you have to decide on that.
Lordship.
What is your objection to that effect?
It was still not reclassified, Lordship.
Premium was paid.
Premium was
Final
paid.
NOC was not issued, madam.
So what do you have to say on that?
Lordship, that can be classified to the commercial class subject to the use for regulated activity only, Lordship. That is, we have mentioned in our affidavit, Lordship.
That is there, I think in para 7 they have indicated,
yes,
my
yes.
lord. That regulated
7 of?
activities can be, my lord, carried.
Page 54.
Para 7 of?
The affidavit filed by the respondent, one Mr. Hirokjyoti Soikia.
He say petrol pump is not, my lord, permissible. Though in fact 100 meters ahead of my land, there is a petrol pump already. Will not go into that issue. But then since I am abandoning it, my lord, I have put it on my affidavit already.
Yes.
Yes. yes.
Earlier it was reclassified. No.
My lord, the reclassification process initially, my lord, it contemplates interdepartmental reports from water department, forest department, etc. Once all this is, my lord, completed under the Act of 2015, the deputy commissioner asked me to deposit the premium. I deposited the conversion premium in 2021, my lord. Thereafter, NOC under section 5(7) of the particular act is to be issued, which directs that the revenue records may be corrected. Before issuance of that NOC, my lord, this issue of eco-sensitive zone had been brought in. We are not disputing that also, my lord, that yes, that is very well a regulation. So there are other industries around me. Today, I am governed by this particular regulation. So let me do something else, my lord. The petrol pump, of course, you say petrol pump is not permissible, I will not do.
Now you'll have to, you are required to file a fresh application.
My lord, no, not required, my lord. The purpose for reclassification is not required to be, my lord, described in the application, my lord. The application only needs to show that my neighboring lands are already commercial. And therefore, based on that, my lord, a report is made, my lord.
Where is the report?
My lord, come to page 26, my lord.
Yes.
25, annexure 8 and 9. This identification of, my lord, the location is already there. I'm surrounded by Nursing College, Pratiksha, Maharishi High School, Tata Godown Industry, and Lime Factory. All commercial activities. Nothing agricultural, Panighati Road, my lord. Everything has turned commercial these days. So therefore, to that extent, my lord, my premium was, my lord, taken. Only issue now is that I cannot open a petrol pump. And if not, my lord, whatever is permissible under the regulation, I will do, my lord. If I violate something, my lord, thereafter it will be a different cause of action, my lord. But then per se, there is no bar on reclassification, my lord, after the premium is deposited. Reclassification হওয়ার বিষয়টা মনে তাতে কি হবে? Technical side number মধ্যে বললো ওটা কমার্শিয়াল হলে এটা ঘরেটাই মনে হয় ছোট করে এটা অনহনে দিতে হবে দলহনে দিতে হবে এমবি ক্লাসে তো কমার্শিয়াল কই দেন হাই না
Show us the provisions of the regulation.
My lord, the regulation is already annexed, my lord. It starts, my lord, from
An act.
the act.
Act. Where is the
Section
pro-
5, Section 5, my lord, procedure for land reclassification,
16,
page 37, my lord,
57.
page 37. It is part of annexer 16.
Yes.
First I apply, then my lord, the circle officer gives a report. The circle officer's report is already there. Then in principle approval is given. That is also there, my lord, in my case. Then after in principle approval, my lord, I am required to, my lord, deposit the premium under section 5(6). That also I have deposited 3,27,000 in 2021. And subsection 7, my lord, is where I got stuck, my lord. After payment of reclassification premium, NOC is to be issued, my lord.
Under which provision?
Section 5(7), my lord. NOC has to be given. Page 38, my lord. After deposit of premium.
So any orders passed by the DC?
No, my lord. He simply sat upon it, my lord. Therefore, we have to come to the.
So has the DC passed and filed any affidavit here?
They have filed, my lord. They have said that, my lord, we are clarifying with the forest department regarding it being it in the.
Where is the everman?
The deputy commissioner's affidavit, my lord, would be at page.
Mr. Goswami,
Page 53, Lord.
53.
Para 6.
filed by whom?
On Mr. Lordship. Hirojyoti Soikia, Assistant Commissioner.
What do they say in their affidavit? But no order has been passed.
My lord, there's no order passed. But in the affidavit, they finally say that it falls within the eco-sensitive zone. There is no dispute. They say that petrol pump cannot be open. I say that petrol pump I'm not opening anyways because the
No, no,
frontage
but-
of the land is gone.
But Have they passed any order
No, my lord.
rejecting it? No.
No, my lord.
You get your updated instructions here.
They are sitting on it, therefore I saw the mandamus, my lord.
Petitioner did not offer for what purpose he will use the land lordship. That is the.
No, that was initially not required, but then when this eco-sensitive issue had come in, my lord, the question of the petrol pump they had raised. I said, okay, I will not do it. I cannot do it also because the land is gone. But then regulated activities are there. So once whether I do a regulated activity after it is converted into commercial or not, would give rise to a separate cause of action. I'm already barred by the law today. Today, I cannot specify that I will open this particular thing there. All will depend upon my finances, so many conditions are there, my
No,
lord.
but in
But
your
then once only
original-
reclassified, I can get finance. or
In
do
your
other stuff.
original application, what was the ground you had given for opening a petrol pump?
Yes.
No. I had given, my lord, petrol pump had subsequently come, my lord.
Oh.
I had given the application saying that all my neighboring land are already commercial. And therefore, the report also of the concerned officials came that yes, I am surrounded by commercial activities and commercial land. And therefore, it is a case where it can be converted, my lord. Basically, agricultural prohibition under this particular act is, my lord, regulated or my lord, thought to be, my lord, controlled, because random conversion of agricultural belt into industrial or commercial belt, my lord, would cause difficulty in other agricultural activities, my lord, in the area. But then whenever, my lord, the whole area, entire area has already, my lord,
See,
been
we don't
converted.
want to close this matter by giving an order that we pass appropriate orders within 1 month, 2 months. So that again, you'll come back by filing a contempt. So we want to find out what is the updated, what have they done with this thing.
Specifically, what we want is that, my lord, I have.
If it is their case that no, we need to know what business, what commercial activity you are going to undertake.
My lord.
Could be one ground, right or wrong is a different issue.
My lord.
Get your instructions here, Mr. Goswami.
Lordship, in our affidavit, we have mentioned, Lordship, petitioner.
That you mentioned at the time when there was an attempt to open a petrol pump. And then subsequently that is abandoned.
Eco-sensitive zone can be classified to commercial class subject to the use for regulated activity only. That is what we have mentioned, Lordship.
That is what we want to know. Is it a necessity that in the application, there has to be a specification for what purpose you wanted the reclassification? And if not, why is the DC sitting over it?
Because the act does not, my lord, prescribe any specific.
There is no specific provision here.
Format there.
That it has to be disclosed.
The object of the act is only to see the judicious growth of, my lord, commercial and agricultural land is there, my lord, so that this balance is maintained.
Matter be posted again on 12th of February, by which time Mr. N. Goswami will obtain required instructions from the DC group.
Lordship, DC Kampu.
Metropolitan. With regard to the application of the writ petitioner for praying for conversion of his agricultural land into commercial land. Let this matter be listed accordingly.
With specific reference to this regulated and prohibited activity.
Mr. Goswami will furnish instructions, will apprise the court as to the requirements, as to the steps taken by the Deputy Commissioner regarding the prayer of the petitioner as contemplated under the what act?
My lord, Assam Agricultural and Land Regulation Reclassification Transfer of Non-Agricultural Purpose Act 2000.
What is the page number here?
Page number, my lord, is page 33, my lord.
33. I'll go page 33. Huh? They will be at. Yes.
May it please your lordship. Lordship, this
Paper is that, my lord, they are
Before he start, may I something, madam? Matter may be taken on 29th. Madam, I could not prepare the matter yesterday because I was rushed to the hospital and I was there till 9 o'clock because something stuck in my food pipe, my lord. That's why, my lord. How did?
The matter, if
Let it be on third,
Yes, ma'am.
3rd February.
Third
The
of
request made by MS A Gayon, matter stands deferred. List again on 3rd of February. Mr. SP Sharma for the petitioner. Yes. Objections are filed.
Yes, my lord.
My
In
lord.
fact,
Hi, ma'am.
if my lord just for 1 minute, my lord. My lord, in fact, the affidavit in opposition, they have admitted they're ready to appoint an arbitrator. And we are saying the unilateral appointment arbitrator cannot happen as per the judgment of the Supreme Court. So that's why we in 11-6. So there is nothing to decide, only the name lordship we have to recommend. So it was just that's the only issue.
Must
Yes. Nothing on 14.
Lord, may I please your lord.
May I please your lordships?
Yes.
Lordships, before you start, my lord, I am seeking, my lord, recommendation today, my lord. Some difficulty today, lord.
Some difficulty today.
Lord.
What is the matter about?
Well, in my respectful submission, the matter stands covered by my lord's judgment in Ram Narayan Shah. My colleague in court will hand over the copy. Malus, the small issue which falls for consideration is that whether the proceedings under section 148 ought to have been initiated by the faceless and not by the jurisdictional assessing officer.
All right, we'll examine that.
My lords have already decided this controversy.
Now, when can you?
Any date, lordship, next week, 29th, lord.
29th.
Lord.
All right, we'll have it on 29th.
As convenient to my lords.
As agreed to by the council for the petition. On the request of the senior standing counsel, Mr. S. Setia, matter stands deferred. We will list it on 29th. Your Mr. Your name, please.
My lords, Rajat Sharma.
Rajat Sharma for the petitioner along with Mr. S. D.
I am deeply pleased.
I'm grateful, sir.
Lordship, Ms. Bora left because she has told me that she is not feeling well.
All right. Council, which is informed that the council for the petitioner is indisposed. Mr. P. Chakraborty appears for the respondent. List again. List again after 2 weeks.
Letter 16.
Lordship, may kindly take up the order dated 9/12/25. On that occasion, the council for the Karbi Anglong, they were supposed to, they have given some calculations, but there were some confusion. They were supposed to give the clarification taken to the APGCL. I'm told that they have given the clarification directly to the APGCL office, the department, and they are in the process of verifying that. I pray for 2 weeks time, I'll for the instruction.
Yes.
All right. 2015 meter, so date will be fixed.
That's true, but the verifications and other things were done subsequently.
So, what is the claim here?
They have
Land compensation.
and Jirat, including Jirat.
You
they
are
have claimed.
who? Landowners.
Yes.
Landowners. According to you, the land has been acquired and no compensation paid or less amount?
No compensation.
No compensation. So what steps are being taken now?
Now, they have submitted some verification report and incorporating some calculation showing some amount. In the calculation sheet, there is some defect. That we have pointed out, and on 9/12/25, Lordship has recorded the Standing Council Karbi Anglong, they were supposed to take instructions. I'm told that the instructions they have directly sent to the department. And then the APDCL is under process. They are looking at the
One
report.
thing I want
given
to
by-
say before your lordship, my lord. On 1/8/2023, there was a direction from this honorable court for a joint verification. Joint verification has been done. Thereafter, another joint verification has been done regarding GRAT. Everything is now complete. Only thing, the amount has to be paid by the authority as per act, my lord. Then the acquisition. The honorable court will not go these things amount to what that will be decided by the appropriate authority. I
Yes,
don't think so. It is
you
important.
have submitted the huh? So how much time do you require?
2 weeks time. Lord. 2 weeks time.
2 weeks.
Lordship.
Or we close this matter directing you to make necessary payments.
Yes,
No,
yes.
Lordship,
As per act.
Lordship may kindly, whatever they have given, they are examining kindly, this is pending for a long time. 2 weeks, my lord, Lordship may kindly allow, let us come, my lord.
MSP Burman for the petitioner, Mr. S. D. Nath, the
For respondent number 5, 6, 7, and 8.
for respondents 5, 6, 7, 8 submits that in terms of the earlier orders, the council for the Karbi Anglong Autonomous Council was supposed to furnish updated instructions in respect of certain rectifications noticed in the amounts quantified in respect of the compensation contemplated to be paid to the landowners like the petitioners. Stop. Under such circumstances, the court permitted the Standing Council KAAC to
APDC.
obtain the updated instructions. Whereas today, when the matter is called up, Mr. D. Nath submits that these instructions have been directly furnished to the APDCL authorities, and presently the APDCL authorities are scrutinizing presently these information is under scrutiny of the APDCL authorities, and he therefore submits that it will be deferred for 2 weeks to enable him to be updated with the instructions. Accordingly, list this matter again after 2 weeks on 20.
Lordship.
20 February,
March.
20.